14A District Court of the County of Washington, State of Michigan, is now in session. All those having business before the court draw near.
Could we have quiet? Go ahead, Mr. Allen.
The Honorable Judge Simpson presides.
You may be seated. Ms. Lundy.
Morning, Your Honor. Ashley Lonnie for the people. Your Honor, at this time, people would waive any conflict between this honorable court and the Office of the Public Defender. The people do not believe that any conflict exists. They would see avoid called out.
Thank you.
Good morning, Your Honor.
Yeah.
Hannah Mackey, requesting permission to practice under Michigan Court Rule 8.120 under Deputy Chief Public Defender Lauren Brown.
Permission to practice is granted.
Thank you, Your Honor. We waive any potential conflict between this honorable court and our office, and if a conflict were to arise, we waive that conflict so that this honorable court can hear these matters.
Thank you.
Thank you, Your Honor.
Court for its part also does not believe that a conflict exists either under Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the people of the state of Michigan versus Tomika Slip.
Hi, Mr. Simpson.
Good morning.
How are you?
I'm fantastic. And you?
I'm good. Did you have a good Christmas?
Yeah, a while back, I certainly did.
Me too.
And you?
I got a Christmas present.
Yay.
Somebody
got one.
crocheted me a teddy bear.
Oh, fantastic.
Yeah, I loved it. And cuddle with it every night. Its name is Brown Bear.
Not going there.
And you still
All
got
right.
that beautiful smile. You still got that beautiful smile.
Andrew Childers is on behalf of Lauren Brown.
Nice of you to finally speak up. Go ahead.
Lauren Brown, Deputy Chief Public Defender, appearing on behalf of Ms. Schlimm, who has already introduced herself.
Yes, she has.
So this is the you hearing. We don't have any updated.
Our office received a report.
I have a date. I have a report received February 19th, dated February 11th. Is that the one you're referring to?
Yeah, I checked our materials. As of yesterday, we haven't received it. We just got it yesterday.
We received it yesterday, yeah.
It's competent. That's true. So the finding is that my client is competent to stand trial. In which case, Your Honor, since we've had a chance to review that, has the court received that same report?
I haven't reviewed the same.
We have no further evidence.
All right. Any other evidence from the people?
Nothing on behalf of people, Your Honor.
All right. The court would find, based upon that report, that the defendant is competent to stand trial. Specifically would indicate that the defendant can understand the nature and objects of the proceedings against her and can rationally assist in her defense. And so the defendant is therefore deemed competent.
Thank you, Your Honor. We will tender a finding and order to the court this afternoon. At this time,
I'm going to need 5 orders.
5 orders for 5 cases. Yes, Your Honor. So at this point, we will to adjourn so that we can do a probable cause conference.
All right.
I think 2 weeks is the minimum you'll need.
Yes.
All right. So probable cause conference will be set for March 13th,
March 13th.
2025.
Did that mean I come back to court on the 14th?
Yes, ma'am.
And we'll talk to you in between that time.
We'll see you in a couple weeks.
Okay, I'll see you later, Mr. Cedric Johnson. Then you
All
are.
right, bye.
My mama watches your podcast.
Okay. Yes, ma'am.
Bye-bye.
All my clients are that happy to see you.
I know. Yeah. It's nice to have
I'm
somebody happy to
sorry.
see. All right, take care.
I'm dismissed. Can I go?
Yes, you can go.
You have a great day. Have a great couple weeks. See you in a couple weeks. Bye-bye.
You too. Court does call the case of the people versus Demetrios Masterostropoulos.
Ellison on behalf of the people, Your Honor.
Your Honor, Joe Simon, on behalf of defendant Dimitri, state your name when you get here.
Dimitris Mastrapostolis.
All right. Greek. He didn't even try, so.
Court noticed.
Yeah, I did.
Requesting the matter be set for preliminary examination, Your Honor, because I know the court prefers it, if it's possible to schedule it for the 25th of March. Court prefers dates.
Two cases in, first was slip and then second. Is all discovery complete?
It actually just finished being complete. Ms. Zenda told me that she sent me the last part of it, so we'll be ready, yes.
Will the people have their witnesses available on the 25th?
We'll do our best, Your Honor.
Preliminary examination in person, March 25th, 2025, 9 a.m. That's before me.
Fantastic.
Yeah. Glad one of us feels that way. Bond will continue. All right, thank you. Court does call the case of the people versus Jeremy Anderson.
Counselor Lonnie for the people.
All done. You can wait if you want.
So as soon as you guys finish your conversation, Mr. Bernstein, you might want to join your client, I think.
Oh,
That's who I have.
oh, okay. Walk over there, man. Good to see you. All right, so we're here for Mr. Anderson, Your Honor. I did not realize that he had been scooped up. So I will have to ask for an adjournment of a week or two, please.
Need you to fill out a form when you get a chance. I'll adjourn the probable cause conference March 13, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the case, people versus Stephanie Serene.
Your Honor. Your Honor, Joe Simon on behalf of Ms. Serene. State your name, Stephanie. And Your Honor, in this case, we're asking to adjourn the PCC a couple of weeks. There's some continuing negotiation. I'm supplying some information to the people. I don't think that request is going to be opposed.
Probable cause conference March 13, 2025, 9 a.m. Bond continue.
One other thing, Your Honor, regarding bond, the magistrate ordered at the time of arraignment, a curious order. My client's been testing for over 2 years through the HPRP program. This matter is quite old. My client has reported it to Laura. She's on probation to Laura. She's serving her probation and testing quite regularly for 2 years almost. In May, it'll be 2 years. So to avoid duplication of testing, the magistrate ordered that we turn the results over to the court, not to community corrections. So I have them. So I told the prosecutor that I would bring this up to the court because I think.
Well, let me just ask, did the magistrate order testing at community corrections and then do it that way?
No, and we tried to get these two community corrections. They said technically they've taken unless.
That's it. They're right.
So
how often is she testing?
every 2 weeks,
Sometimes weekly.
sometimes weekly. It's random, but it kind of averages out. I have 2 years of tests right here that I can give to the court.
I don't want to hold those. So here's what I'm going to do. I will order testing at community corrections. And it's Laura that's testing her.
Well, it's under Laura's supervision, but she tests that as at a lab. That's not their own lab, is what I'm saying. But community corrections said that they would accept these results if she signed a release, which she's totally happy to do, but they needed this court to accept or order their supervision or something like that. Sorry.
Well, yes, what they want is I have to order community corrections testing and then permit the testing to occur at the facility.
Thank you.
And I'll order that. And could I get a community corrections order on this? It's just the frequency of the testing. Maybe you test approximately every,
It's I have to check in Monday through Friday and it will tell me if I have to test or not.
got it. So what I'm gonna do is I'll order weekly testing through. And Mr. Simon, if you could. So I've signed that order. And so I'll order that testing, and if you could get to, and the, testing facility and just put on there, she may test,
The name of this.
whatever the name.
It's usually because
Yep.
urgent
I
care.
put
It's through.
those there.
Yeah, yep.
What are these?
You're next. They're individual. I'm just
Got it.
working.
Okay. All right. All other respects, bond will continue.
Thank you.
Who's gonna adjourn to March 10th?
13,
13th.
I think. That file's long gone.
Yes, 13.
All right.
And tell me what
You're welcome.
what?
Recovery.
Court calls the case people versus Ashton Dew. You guys are gonna have to.
Counselor Lonnie for the people.
All right, thank you.
Thank you. For the record, Your Honor, Joe Simon, on behalf of Mr. Dew, state your name.
Ashton Dew?
Your Honor, in this case regarding the PCC, we're requesting an adjournment. The reason is my client was ordered through the circuit court for a mental health evaluation. Judge O'Brien signed an order, I think yesterday, or the day before. I was out of town. There was a petition requiring my client's evaluation. And I had a copy of that order. Actually, that-
Well, when's the next date before Judge O'Brien? And I'll just go around that.
So, Your Honor, it's not clear. The evaluation is supposed to take place prior to the 8th, sorry, she signed an order for evaluation and transport for the jail to take him to the University of Michigan Hospital. And that's supposed to happen by March 8th. And I'll be doggone if I can't. You get that back, right?
I did.
I'll find that order and bring it to the court in a minute, but the point is, he also, at the time of his arraignment, was ordered because a mental health evaluation was being sought. The magistrate ordered that he could go to a mental health facility, but he had to first be tethered, a GPS tether. And the sheriff's department was waiting on the court today to see if, with the circuit court order, if that changes anything or not. And let me just, I'm probably just.
Well, Judge O'Brien ordered that he be transported there under the supervision of the sheriff.
That's correct.
So there's no need for the tether, right?
And Your Honor, what I'm not clear on is it needs to be transported just for the
Oh,
evaluation
sorry.
or for evaluation and treatment at this point.
I believe it's the evaluation and let me just find that.
So, all right. So the idea is he transported pursuant to Judge O'Brien's order, he be transported, go through the evaluation and then come back to the jail.
That's my understanding, what I think should happen.
That's the order.
Yes, sorry about that, Your Honor.
No, it's okay.
Yeah. So as I read this, he should be able to just be transported, remain in police custody, go through the evaluation and return to the jail.
I think under the order, that is exactly what's supposed to happen.
And
Because he's being taken there in protective custody.
if the court could do anything to clarify that for the sheriff in this file, because they were a little confused about that, yes.
Want me to just say it out loud or what do you want me?
I mean, I don't know if you need to write something or something like that. but-
So I'll do it this way. That's at U of M.
Yes.
I think that's what it said, Your Honor. University of Michigan Psychiatric Emergency Room, yes.
Stated as artfully as they would. So I'll have his bond continue. I've written on the register of actions that defendant does not need the tether for transport to U of M under the Washtenaw County Sheriff's Office's custody.
Thank you. Thank you, Your Honor.
Deputies must remain with him and transport him back.
Well, they would according to her order. I mean, I'm not ordering that he go there. I'm just clarifying the tether portion of this order.
Thank you.
Your Honor.
Thank you.
What was the next date, Your Honor?
Did I give one?
I don't
I
think
don't know
so.
that we got one.
You said that's going to be done on the 8th, but I don't
It's
know
an
when we
honor
have a
report.
report.
Yeah.
So I can do the 20th or 27th.
Hold on. Sorry.
20th or 27th. I
Um,
don't know when you think we'll have a report.
That's a good point. Probably the later date, Your Honor.
27th.
Smarter.
Probable cause conference will be adjourned March 27th. You
Your
can't
Honor,
do that. It's spring break.
the 20th would be better for me, but thank you, Your Honor.
March 20th, 2025, 9 a.m. Bond will continue with that added condition. And you can tell Lisa she's welcome.
Okay.
Court calls the case versus John Cahill.
That's the line for the people.
And Your Honor, Joe Simon on behalf of Mr. Cahill. John, state your name.
John Cahill.
Thank you.
Your Honor,
We have reached a resolution in this matter. Unfortunately, Mr. Simpson was not able to speak to Mr. Cahill this morning when I informed him of the offer. It's my fault for letting Mr. Simon know this morning. I think he's gonna request an adjournment, but we are there.
yes,
Apologize.
yes. Mr. Cahill does not even know that an offer that I think will resolve the case has been tendered this morning. I did try to call him, but as the court can see, his nephew is using the phone that I tried to call him on
Right.
to make the Zoom connection. So asking for a brief adjournment because I believe.
13th, you think you get it?
Oh, this, yes, I'm definitely.
Okay. Probable cause conference will be adjourned March 13th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court does call the case People versus Nicholas Elka.
Morning, Your Honor. Sam Bernstein with and on behalf of Mr. Elka. Say your name.
Nicholas Holka.
Your Honor, we've been working towards a resolution that will ultimately save us from a lengthy preliminary examination, so I'm hoping for an adjournment to make that happen.
How much time are we looking at given?
2 or 3 weeks, Your Honor.
Probable cause conference, March 20th, 2025.
Thank you, Your
9
Honor.
a.m. Bond continue. Thank you. Court calls case People versus Anna Cardona Ramirez. Oh, my goodness. I mean, hi.
Good morning, Your Honor. Steve Tremontin with and on behalf of the defendant, Ms. Cardona Ramirez. Could you state your name for the record, please?
Cardona Ramirez.
Your Honor, there is a fully executed substitution of counsel in the file.
I've signed up on that.
Your Honor. In terms of the PCC, discovery is complete. We'd ask that the court set this matter for preliminary examination in person at the court's earliest date.
People have their witnesses available. What's my next name? 11. People have their witnesses available March 11th.
We'll do our best, Your Honor.
Preliminary examination in person, March 11th, 2025, 9 a.m. That's before judge.
Your Honor, and may I address briefly?
Sure.
Thank you, Your Honor. Ms. Cardona Ramirez was placed on tether by the magistrate over a month ago. She did go to mental health treatment, inpatient, successfully completed that. She was released 2 weeks ago. She's been in total compliance of her bond. Obviously, the tether is creating a financial hardship. She certainly intends to follow all the other conditions of her bond and not go back to the marital home. We would just ask that the court remove the tether.
I don't need a response from people. I'm going to decline to do so at this time. I'm going to leave the tether in place, and certainly you can bring that up with Judge Falvo following preliminary examination.
Thank you, Your Honor.
Thank you. I'll need an order to. Court does call the case of the people versus Elroy Love, 3 cases.
Ally's in on behalf of the people, Your Honor.
Wow.
Good morning, Judge. It's good to see you too. Christina, go ahead. I'll take it.
No. This expression is joy.
Oh, good.
All
Good.
right.
It's mutual for what that's worth.
Yeah, all right.
Christina Costantino, and Judge, I am representing Mr. Love in the case numbers ending in 1442, 1460.
Torshell Feaster, Assistant Public Defender, also on behalf of Mr. Love on the remainder.
My look toward you is not joy.
I understand.
Okay.
Judge, in my cases, I was just appointed on this case, I believe on Tuesday. At this time, discovery is not complete. I don't have the media discovery, and I need that obviously in both of those. So that would leave me with nothing left to do but ask for an adjournment of the PCC if the court.
I would echo those concerns. We can try to work towards the global resolution, Your Honor.
All right. Probable cause conference in these matters will be adjourned March 13th, 2025, 9 a.m. Bond in these matters will continue.
I believe.
And
Go. Oh,
yes, Judge, if I might address bond briefly.
okay.
Thank you, Judge. My client is 31 years old. He is currently the manager at Best in Games, which is located locally in Ann Arbor. He does work full-time. He's worked in that capacity for the last 8 months. If he is able to be released from incarceration in the next week or so, he will still have that job lined up for him. He has confirmed that with his employer. We did receive a letter from his brother confirming that if released, he could reside locally with his brother. His brother is a full-time employee at Ford and has no current ties to the criminal justice system. If he would be released, Mr. Love would be actively participating in community mental health. And he does also do nonprofit work with churches where he helps raise awareness for churches. He has 2 children. He provides support for. We are asking if the court would consider a 10% provision in each of these.
Response from the people.
Your Honor, I believe Mr. Love has a hold on license as the judge. Also, we would be objecting to any modification of the bond. He has numerous DV conviction or dismissed DVs as well as DV convictions over the past couple of years, including a dismissed from 2016, a DV conviction of 17, another one 17, 18, 19. 2022, dismissed 2022, and then another dismissed in 2023. I would just, especially if I'm facing I don't believe it's fine.
Judge, could I just briefly respond? With regards to those, I just point the court's attention to the date of the alleged offense in these cases. These cases are allegedly from 2023. These cases, it's my understanding, were dismissed because the complainant failed to appear at a preliminary examination and then were subsequently reauthorized.
I don't know if it's your case, but one of the cases is from 2024.
I don't believe that's my case.
That's right, which is another DV. So.
Well, with regards to my cases, Judge, these are reauthorizations from 2023. 2 years have passed now. I think that goes to the unlikelihood of conviction in these matters. Thank you.
Only thing I'll add, Judge, is that I believe my client was out on a PR bond previously, and he was put into custody because he misunderstood and missed the court date. He had been on Zoom for the PCC. The exam was set. He thought he could be on Zoom, and he was actually supposed to be in person. This is the case.
And how do you come back into custody?
He was, my understanding.
It was a traffic stop, Judge. It's my understanding there were no additional charges that were brought as a result of his encounter.
So he
with
was a
police.
traffic stop, he was on his way to be able to turn himself in?
Quite possibly, Judge.
Yeah, okay.
Quite possibly.
I believe in unicorns too. Motion for bond reduction is denied. Bond will continue in these cases.
Thank you very much, Judge.
Is that it?
It is. Can I provide it? I'm sorry.
I don't know who, and
I'm sorry, I didn't.
who done the other, what was the one?
Oh.
The one that came back.
Yeah, with the 5 counts, clarify.
Yes.
Yes.
Could someone from the prosecutor's office, Ms. Constantino, approach maybe dear? Court does call the case, People versus Myron Barnes.
And Assistant Public Defender Lemie Saab on behalf of Mr. Barnes, who is not here and has not.
Were you just hoping that?
I was
Here,
hoping
but-
I would conjure him up into existence, but he's not here. And I have not had contact with him, Your Honor.
Bench warrant will issue for defendant's failure to appear. You did see his
I did.
violation,
Yes, Your
which
Honor.
may explain his absence. Bond will be set in the amount of $25,000 cash surety.
Thank you, Your Honor.
That warrant will issue immediately. Court calls the case of the People versus Warren Abbott. Okay, this happens every week.
So is this one?
Yeah, we're working on it.
So, Mr. Feaster, I think you're the ranking PD. No, Mr. Brown's here. So, Ms. Cannon, we're gonna need to like chain her to a chair or something, or what are we gonna need?
What's your name, sir?
Warren Abbott.
She's requesting a 2-week adjournment of mental health for a referral.
Ready, Judge. Torshell Feaster, Assistant Public Defender on behalf of my client. Please state your name for the record, sir.
Warren Abbott.
Thank you, Judge. My understanding is we're requesting an adjournment on this file, please.
Yes, sir.
I don't have the prosecutor's, I have the form. I don't have the prosecutor's signature. I don't have anything else. I'll give the 2-week adjournment, but
That's for the mental health court?
yes,
I thought I signed it, but okay.
I don't, but I mean, I'll sign off and
I'll make sure that may I approach this on that order?
yes. And then what I will do in this instance, probable cause conference, is it gonna happen in 2 weeks, you think?
I would doubt that, Judge.
What'd you say?
I would doubt that.
Yeah, it's asking for a 2-week adjournment. I don't know. I think we're just gonna be back, not
I would last for 3 or 4.
probable cause conference, March 27, 2025, 9 a.m. Bond continued.
Thank you, Judge.
Court calls case People versus LaShawn Courtright.
Edward Dukas on behalf of LaShawn Courtright, but not with. May I approach real quick with prosecutor?
Sure. All right, the record should reflect you had a bench conference in this case. The court will pass this matter. Thank you. Court calls the case People versus Nelson Campbell. 3 cases.
Hannah Mackey on behalf of Mr. Campbell, who is approaching to my right. Please say your name for the record.
Nelson Campbell.
All right.
Your Honor, at this time, we would like to set this matter for preliminary examination and all discovery is complete as far as we are aware.
In all 3 cases.
Yes, Your Honor.
And would the people have their witnesses available on the 11th?
We'll do our best, Your Honor.
Preliminary examination in person will be set March 11th, 2025, 9 a.m. That's before Judge Washington. Bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls the case of the people versus Tadris Bentley.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Bentley, Your Honor, who's approaching.
Your name, sir?
Tadris Bentley.
Take your hands on your pocket.
Right.
Put them on your side. It's fine.
All right. You're requesting an adjournment in this case.
Yes, Your Honor, we're asking for an adjournment so I can get the media and review with Mr. Bentley.
Probable cause conference, March 13th, 2025. 9 a.m. Bond continue. Court calls case people versus Thomas Gray.
Good morning, Your Honor. Good morning, Judge. Can you hear me okay? I'm not hearing you, Judge.
Hang on 1 second. Mr. McGee. Is that Gray?
Yes.
You guys need to move so we can get through.
Ashley Moen, Assistant Public Defender, appearing on behalf of Mr. Gray. State your name.
Thomas Gray. I don't know if the Attorney General stated his appearance or not.
I'm sorry, Your Honor.
Did you state your appearance? I'm sorry.
I did not, Judge. I'm Special Assistant Attorney General Mitchell Wood for the people.
Thank you. All right. What are we doing on this case?
First, for these two matters, we are waiving, Mr. Gray is waiving his right to a preliminary exam.
Is that right, Mr. Gray? Yes, sir. You understand the preliminary examination is proceeding where the people would have to show by probable cause that the offense is alleged. So you understand you'll not have that hearing in either case and that you'll proceed to circuit court for further resolution. Yes. People also waive their right.
We do, Your Honor.
Preliminary examination having been waived, defendant is bound over on a single count in each case.
We waive formal reading of the information and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrials in these matters will be set for
March 10th at 1:30 before judgment.
March 10th, 2025, 1:30 before Judge Hamoud.
Judge, may I address bond?
You may.
First, for case ending in 5095, his bond is currently 13,429. I understand that the bond is typically 25% of the balance, but the Assistant Attorney General confirmed with me that his balance is $5,139. So his bond should be 1,284.
Well, that's because why?
I actually am not sure. I wasn't present at the arraignment, but it looks like there was an error because there are two cases and this was his old bond on the other case.
All right. So if his bond changes.
Well, I did want to address that, so that is adjusted, but also I was going to request a reduction in his bond because a couple things. He paid the 25% in 2023. He got a warrant for a failure to appear. At that time, he was homeless. Since then, he started working. He's being garnished for these cases. He's in truck driving school. And he's also the sole caregiver of his father, who is very ill. We're requesting a personal bond, if necessary, a GPS tethered.
Well, hold it. You're asking me to do something the statute really doesn't permit me to do, right?
He did pay the 25% previously. Now he was arrested on this warrant. I mean, yeah, he's back here in custody because he had a warrant for the failure to appear. So I am asking for a reduction at this time because he's paid the 25% previously.
So you're saying in each case, he posted the 20?
Yes, in 2023, he paid.
And then he didn't appear.
Yes, because he was
Has he been
homeless.
paying his child support currently? I mean, after posting, was he paying the child support?
He's indicating to me that he has.
Yes.
No, he has not, Judge, if I may.
Yes, sir.
No, he hasn't, Judge. He's had an intermittent wage assignment for small payments since he absconded back in July of 23. He's paid maybe a couple $100 in each case, all total over the last year and a half while he's absconded, Judge. Judge, but he did pay, and I don't know if your records reflect that. Back in April, I'm sorry, hold on, May. I'm sorry, Judge. On June 1st of 23, you ordered that his bonds. He had a $3,600 or 3160 bond in case number ending in 5077. He had a $780 bond in case number ending in 5095. And on June 1st of 23, you said pay it over. Like you always do. You made a cash bond. You said pay it over. Never happened. It's not on the books. I don't know why, Judge, but I assume that your court still has these two bonds, 3160 and 780, but they were never paid over. So if, Judge, I know you have mechanisms to look into these things expeditiously. If you could, that would be great, because those bonds need to get paid over. But as far as go ahead. I'm sorry.
I have, okay. So that we're clear as to how this works, these go over wherever the cash bond is posted, it goes to Ann Arbor, to the 15th District Court. And I ordered, and I don't have the date, but I ordered that the bond in his case, because it did come up, that was to be applied to the FOC case. Okay, I have some information.
Okay.
Okay, so apparently somebody got something because finally, I guess they got paid over yesterday.
Oh, okay, that's good.
I
also did want.
the checks were cut and it says what does it say?
Well, like, no, it just shows that there was a check cut and sent to circuit court.
Okay, so the note indicates a check was cut, sent to circuit court. I don't know where it is. We last time had to have them hand deliver in a case. So
Last time I submitted an order, and when I submitted the order, I was told that it should have automatically been done, but I am very happy to do the
it should have
order.
automatically been done
Right.
because it's the magistrate's order.
Right.
That once he paid it, it would be then sent to 15th and then sent to applied to the FOC
Exactly.
case.
Yeah.
All right. So so it's not showing anything paid, but my concern is he's also not paying what is his amount.
The Assistant Attorney General is saying that there are sporadic payments, but he is being garnished, and just so he knows, it is being split between about 4 cases. So
Judge,
if he's
I
not
have
meeting the
I have
cycling amount,
records.
likely that's why, but it is taking about half of his check every week.
It's not, Judge. I'm sorry. I have the records from the Michigan Child Support Enforcement System. I have a report dated February 24th. It shows that he did have in October of 24, he had a wage assignment for a couple of weeks. And again, all total, I'm looking, Judge, he paid 71 on October 25th, another 53 on October 25th, 49 on October 25th. So these all, I don't know why they came in different amounts, but so one period in October, and then in December, he paid on December 6th. There was a wage assignment, but there's been nothing since then. So I don't know where he thinks, does not have a current wage assignment. The last time anything came out was in December of 24. Judge, we know the purpose of these matters is to get him paying, but he hasn't been paying. I can tell you that.
That is something that we can definitely address in district court now that the case has been bound
Well,
over.
you
However,
can address it in circuit court. You can address it before Judge Hamud in terms of.
Right.
So I'm going to deny his request for a bond reduction or any change in the bond at this time. I want to leave the bond where it is. He's set for March 10th. You'll see Judge Hamud. You guys can deal with it at that point and try to get this straightened out. We will, both for the people's sake and for the defendant's sake, we will make a call over 2/15 to try to make sure that the check hasn't been cut and is sitting in a pile to go over. We'll try to make sure that it goes over if it hasn't gone over, so that there's a correct number when he gets there that they're dealing.
Perfect, Judge. And one more matter regarding bond. I have no problem, Judge, if you reduce his current bonds, because he's been absconded for 1.5 years. The bonds were set at the full amount of the original arrearage. I have no problem if you reset those bonds to 25% of his current arrearage. And then if he pays that in by
That is typically not my practice. I would leave that to Judge Hamud because it's not my practice, because the bonds only went up to the full amount because he failed to appear. So I'm going to leave those where he is. He needs to be here. And the only reason that he's here is that he hasn't done what the court's been ordering in the past. So I'm going to leave it where it is. Motion for bond reduction denied. We'll make sure that the checks get over and you can see Judge Hamud. Thank you.
Thank you.
Thank you very much, Your Honor. Always a pleasure.
Yes, sir. Court does call the case of the People's State of Michigan versus Clarence Broach.
And then on behalf of the people, Your Honor.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Broach, who is approaching. Please state your name for the record, sir.
There's Broach. Thank you.
Thank you, Your Honor. I was first able to connect with Mr. Broach today. I have been able to provide him with discovery and get some updated contact information. To that end, we're requesting a 2-week adjournment if the court would allow to discuss discovery.
Probable cause without objection will be adjourned March 13th, 2025, 9 a.m. Bond continued.
Thank you.
Thank you, Your Honor.
Court does call the case of the people versus Dana Kirby.
Edward Droops on behalf of Dana Kirby. This is a waiver, Your Honor.
Your name, ma'am?
Dana Kirby.
All right. This court's understanding that you're waiving your right to a preliminary examination. Is that correct?
Yes, sir.
You understand that's a proceeding where people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. Go ahead.
Your Honor, we stand mute, waive reading.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for March 10th, 2025, 1:30, Judge Hamud. Bond continued.
Thank you, Your Honor.
Thank you. Court calls case of the people versus, is it Aisha Brown
And then
or Asia Brown?
Hannah Mackey on behalf of Ms. Brown, who is approaching.
Asia Brown.
Asia Brown.
Your Honor, at this time, we'd like to set this matter for a preliminary examination. All discovery is complete as far as we are aware.
And would the people have their witnesses available on the 11th?
We'll do our best, Your Honor.
Preliminary examination will be set March 11th in person before Judge 9 a.m. before Judge Valvo. Bond can,
Thank you, Your Honor.
Thank you, Your Honor.
thank you.
That's it.
And that child. Yeah. CC, Judge Valvo. Court does call the case People versus Christopher Miller.
Edward Lucas on behalf of Christopher Miller. Christopher Miller, sir.
All right. I have before me a plea form. Is that what we're doing today?
Yes, Your Honor.
Right. The court's understanding of the plea agreement is that the defendant will be pleading no contest to the use of a controlled substance, that being cocaine, the 1-year offense. Upon his successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's correct, Your Honor. That's correct, Your Honor.
All right. Has he signed an advice original?
Yes.
The basis for the no contest plea is,
Lack of memory, Your Honor.
may I have him sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name.
Christopher Graham Miller Jr.
All right. Sir, it is this court's understanding that you're going to plead no contest to the charge of use of a controlled substance. Is that correct?
Yes, sir.
That's a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. You understand that?
Yes, sir.
Do you understand what a no contest plea is?
Yes, sir.
All right. 2 things about it I have to make sure you understand. First thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, sir.
Still wish to plead no contest?
Yes, sir.
And to that charge, how do you plead?
No contest? No contest?
You understand that by pleading no contest, you will not have a trial of any kind.
Yes, sir.
All right. You signed an advice of rights form today. Is that correct?
Yes, sir.
Any question regarding any of those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
and of your own free will.
Yes, sir.
The court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 234638. Any objection to the court having reviewed that report?
Objection, Your Honor.
No, Your Honor.
Based upon a review of that report, the court does find that there is a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court?
Defense is satisfied.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
March 12th at 9 a.m.
March 12th, 2025, 9 a.m. That's before me.
Your Honor, if I may address bond.
You may.
I did, my client wanted to address bond last time that we were here. He was previously remanded. The hearing before that, he's had some opportunity to think about his actions that he took. And he's going to be under the power of the court, and you will be the sentencing judge. I think that he'd be compliant and doesn't want to spend additional time in jail. I think that if he were to be released, he would properly test at community corrections. Everything should be out of his system at this point, including alcohol. And he would report.
Everything should be out of his system and he won't show up for testing drunk?
No, sir.
He will not.
Really?
I promise, sir.
How do I know that? You promised me before.
He is very apologetic. I have talked to him in custody about that. He would meet with probation. There's a lot that goes on to that he can provide for the sentencing, and he knows that you're going to be watching over him, and he knows that there'll be an immediate warrant, and he needs to take care of this. So I'm asking that he has it reduced down to a PR bond and community corrections order be put back in place.
How long has he been in?
21 days.
Sir.
Maybe 20
Was
days.
not testing and drinking worth it?
No, sir. Absolutely was not. Trust me, I got a lot of bad things that happened while I was in here with the family, so I understand that.
All
my
your fault. All
my
your
fault, sir.
fault.
Absolutely. And he was nice enough to give me the chance, and I blew up my dang self. So that's what made it even harder while I was in there, knowing that I was in there for my own selfish act.
I'll send you over to community corrections. You're gonna test clean. No. Goes over. Been drinking. Did you think you weren't gonna get caught?
No, I knew I was, sir. But once I told you I was gonna go there, I went.
I gotta figure out a way not to look so stupid up here. Because some people think I am. I don't know. We'll prep a new community corrections order. His previous bond is reinstated. I dare you to do anything between now and the 12th circuit.
Oh.
No, you make your own choices. But you now understand what I will do.
Oh, absolutely. I understand. You definitely don't tolerate it. I learned that the hard way.
Thank you, Ron. Give me a call when you get out.
Thank you, sir.
Court calls the case of the people versus Iron Brown.
The people.
Michael Gaddy, Assistant Public Defender for Mr. Brown, who should be present via Zoom, Your Honor.
Hey, my name is Aaron Brown.
Thank you, sir.
Your Honor, we'd ask the court to set this matter for a preliminary examination.
Your Honor, there was an offer to waive preliminary examination and seek HIDA in circuit court. I understand that's being rejected.
Yes, Your Honor, we're asking for an exam.
Discovery is complete, sir.
Yes, Your Honor.
People have their witnesses available March 11th.
Your Honor, could we just go one more week, please?
Any objection to that?
Yeah, it just occurred to me that in reviewing the file, I didn't see any security video. If there is, I'll request it before the exam.
Well, but I don't want it, if it's not there, that's not going to be the basis to adjourn.
Okay.
So what do you want to do?
Your Honor, why don't we, if it's okay with Ms. Lundy and with Your Honor, why don't I ask for an adjournment of the PCC so I can see if there's any security cameras available.
Probable cause conference adjourned March 13th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
I'll need a green sheet, Mr. Guy.
Yes, I'll fill one out right now, Judge.
Court calls case of the people versus Anthony Warren.
Ashley Lonnie, people in all matters.
Assistant Public Defender Asi Bashir, here on behalf of Anthony Warren for 24F41590.
Anthony
And-
Warren.
Sorry, Judge. And good morning, Your Honor. Sydney Rushing, appearing on behalf of Mr. Warren in case ending 0128.
So who did this? You did that?
Yeah, but I got.
Oh, okay. No, I thought, no, if you did it, it's fine. I thought Rushing was trying to do something.
What, submit something on a white paper versus a green paper? Judge, I would never.
Yeah, trying to.
I would never.
Slip something by me. I just.
Not
Okay,
me.
if you did. I'm good. All right. What are we doing on Mr. Warren's cases?
Your Honor, in case, I'm sorry, in case ending in 0128, there is some outstanding video discovery that the people, I believe, are getting. So, Your Honor, we're going to have to seek an adjournment on Mr. Warren's case ending in 0128.
Hey, and on the other matter,
On the 1590, Mr. Warren would like to set for preliminary exam.
okay. So on the 128 matter, I will adjourn.
I'm sorry, Your Honor. Sorry, Your Honor. 1 second. So- So my client's understanding and is it okay if I address, Attorney Rushing?
Your Honor,
You want to talk to Ms. Rushing?
Or
Your
just,
Honor, I
No,
know.
go ahead. I don't
No, no.
care.
Your Honor,
It's here.
Your Honor, I already know what is going to be said because we had a different game plan coming in today. However, it was brought to my attention this morning just before the docket started that here was the outstanding video. And I know that Your Honor will not schedule this matter for a preliminary examination without that being done. So that's why there is the change.
She called you inaudible.
I did. A Hail Mary.
Understood.
Yeah.
All right, thank you. We just needed to clarify that. So at least on this,
So what do you want to do? I mean, if discovery is complete on your case, then I'll set it, but I mean.
would you want to adjourn now as well?
No.
Okay.
Or I'll wait.
Sorry, Your Honor, I wasn't.
No, it's okay. You might want to push down the microphone because everybody can hear what you said and it's being recorded. But, okay.
Judge, I'm still here. I'm just letting you know, I'm still looking.
No, I know, you're still here. I don't know. Ms. Bashir they just turned around and had their own conversation.
What's going on in the case?
It's just like calling a Janaza case.
Like that,
What?
cases go together?
Not necessarily. It doesn't mean. At least Ms. Bashir was in the room.
They do, they can do them. If anything, it just becomes.
I know you've said nothing today and I think, I know, you're just sitting there, but
Continue to.
it's like an easy target.
Yes.
And apparently I have a lot of time, so I'm just filling space.
Thank you for your patience, Your Honor.
That didn't really happen. I didn't really have patience, but go ahead.
I'd like to confirm that we would like to set for exam on 1490.
149. I mean,
Sorry.
159.
1590, sorry.
You want that one set for exam?
Yes.
All right. And on that matter, discovery is complete.
There is surveillance that I've requested. We haven't had at least one adjournment on that matter, and Mr. Warren is in custody. And so we've discussed this and he would still like.
But that won't be, I mean, I don't know how important that is for your case, but it won't be a basis to adjourn that you don't have.
Yes, yeah. So that is why we're, he's in custody. We are not adjourning. We'd like to demand an exam anyway. And there was a previous adjournment in order to get that discovery.
Preliminary examination in that matter will be set for, on that case, March 11, 2025. 9 a.m. That's before Judge Valvo. It's in person. On that matter, bond will continue. On the other case, I will adjourn that out, waiting on the.
And Your Honor, I did disclose the police videos this morning. I was able to find them in the system, so they should be over to Ms. Rushing very short order. We can do a week on that one if the court will allow, since he has custody.
That'd be greatly appreciated. Greatly.
We already have 141, but what the heck, more merrier. March 6th. 2025, 9 a.m. Bond continued.
Thank you, Judge.
Bring a lunch.
Oh, sorry. Your Honor, I just one other matter to address. I did see that this is scheduled for a bond violation hearing, but I did review the report for the 1590 matter, and it appears that the report is dated February 1st. Mr. Warren was arraigned on February 2nd. He wasn't under bond.
I know, I saw that.
Okay, great. Just wanted to clarify and make sure.
Unless you want me to violate it.
No, I just wanted
Okay,
to make
thank
sure
you.
that that's the record.
I'm done.
Great, thank you.
Court calls the case, People versus Jesse Crampton.
Morning, Judge Mike Gill, public defender on behalf of Mr. Crampton. Your Honor, I have submitted a green sheet. I am requesting an adjournment for the reasons stated in that sheet. He was taken from the jail. I confirmed that with jail staff yesterday.
We have no anticipation of any.
No, I found out late yesterday afternoon where he was.
So why don't I do this? We'll do March 20th, 2025.
Thank you, Judge.
And bond continue. Court calls case, People versus Jeffrey Williams.
And good morning, Your Honor. Sydney Rushing appearing on behalf of Mr. Williams, who's approaching the podium. Mr. Williams, can you state your name, please?
Jeffrey Leon Williams.
Thank you.
Hello, sir.
Your Honor, you
requesting an
stated
adjournment.
yes, Judge. And I just want to let Your Honor know that if I was submitting it on a colored sheet, it would be pink. It'd be pink, not white. Just want to let you know. That would be my quick slide.
Yeah, I know that. Which would irritate me probably more than these green lines.
Highly likely.
They're
But yes,
beautiful.
we are just seeking the adjournment. I do believe that there is outstanding video discovery. So just a brief adjournment would
right.
appreciate.
I'll adjourn this matter out March 13th, 2025, 9 a.m. bond in this matter will continue.
Thank you so much, Your Honor.
Thank you, sir.
Have a great day, Judge. That's it for me.
You do the same. Court does call the case, People versus Harold Dennis.
All right, the attorney appeared on behalf of the people.
Stephanie Cadden on behalf.
Go ahead.
Stephanie Cadden on behalf of Mr. Dennis, who is appeared to our right. Mr. Dennis, could you please state your name for the record?
Harold L. Dennis.
Thank you. Tanaza, you say nothing all morning. Nothing. Nothing. You sat there quietly, finally behaving yourself. And then when I call the case, you are disruptive to Miss Curry, so she is delayed. You're going to sit down now, aren't you? Thank you. All right. What are we doing on this, man?
Your Honor, I did submit a request for an adjournment for 3 weeks. It's my understanding prosecutor is not objecting.
That's correct.
All right. Probable cause conference will be adjourned March 20th, 2025, 9 a.m. bond continue.
Thank you so much, Your Honor.
Alan,
so
keep on watching. I swear I will tether her. Court calls the case, People versus Mark Capaldi.
Ashley Moen, Assistant Public Defender, appearing on behalf of Mr. Claude.
Mark Caldy.
We are requesting an adjournment. We have not been able to go over the media discovery and for plea negotiations.
Probable cause conference March 13th, 2025, 9 a.m. Bond continued.
May I address bond? Please.
Sure.
Mr. Capaldi is, he's a sole caregiver of his 77-year-old grandmother who was just released from the ICU. He maintains their family home and farm. He's self-employed. He currently has a $25,000 bond. We're respectfully requesting opportunity to post 10%.
Any response from the people?
Your Honor, the people will be opposed to any plea reduction in this case. As the court can see from the charging documents, this is an arson matter. In this case, the troopers responded out to a neighbor of the defendant who had called the police after being informed that there was a bale of hay on fire in front of his house. And it's one of those very large bales that the court may be familiar with that are used in farming and for the feeding of animals. The troopers arrived on scene and were able to follow tire tracks from the scene to the defendant's home. and found broken pieces of wood at the scene where the fire was that in their mind matched up to the trailer that there was hay bales on at the defendant's home. So I do believe the likelihood of conviction is very high in this case. The court is familiar with the incredibly dangerous nature of arson in and of itself, and I also let defense counsel know that there's a warrant request pending for an OUID for this defendant as well.
Anything else?
No.
Motion for bond reduction denied. Bond will continue. Thank you. Court does call the case, People versus Eric Fowler.
Ashley Lonnie for the people.
And Matt can't be at the Fowler, who is approaching. Say your name for the record.
Eric Fowler. What are we doing?
We are asking for a 2-week adjournment awaiting body cam media discovery, Your Honor.
That's correct, Your Honor. Mr. Brown emailed me about that. We're working on it.
Probable cause conference, March 13th, 2025, 9 a.m. Bond continues.
Thank you.
Thank you, Your Honor.
Cause case, People versus Cameron Curtis.
On behalf of Mr. Curtis, who is accused by right, Mr. Curtis, could you please state your name for the record?
Cameron Curtis. He's waiving exam.
Yes, sir.
Sir, is that a correct statement? You're waiving preliminary examination? You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed? Yes, sir. You understand you'll not have that hearing and you'll proceed to circuit court for further resolution? Yes, sir. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant bound over to circuit court on all 3 counts. Ms. Cannon.
I would waive it, the reading of the information, Your Honor. We waived reading of information and stand mute.
Defendant in every way, form of reading, standing mute. Court will enter a not guilty plea as to all 3 charges. Pretrial in this matter will be set for
March 10th at 1:30 p.m. with Judge Hamud.
March 10, 2025, 1:30, Judge Hamud. Bond continue. Thank you.
Sorry.
Court calls case, People versus Durantu Francis.
Ashley Lonnie for the people.
And good morning, Your Honor. Assistant Public Defender Chinazai Carey on behalf of Mr. Rantu Francis, who is appearing via Zoom, Your Honor.
Ms. Francis, state your name for the record, please.
Durantu Francis.
Your Honor, we're requesting an adjournment in this matter. We're still in the midst of negotiations.
Welcome.
Thank you.
Morning to you.
Good morning to
Nice
you
to
as
hear
well.
from you.
Thank you.
Not true. You sounded good, didn't it?
I like to believe it.
Our cause conference will be adjourned March 13th,
Thank you. Your Honor.
2025. 9 a.m. Bond continued. Court calls case, People versus Emmett. Is it Aaron Reich?
Yes, Your Honor, it is.
No, he's busy talking to them.
Assistant Public Defender Jay Bellinger on behalf of Mr. Aaron Reich, who appears by my side. Mr. Aaron Reich, can you please state your name for the record?
Amit Aaron Reich.
All right.
And Your Honor, we are asking for a preliminary examination date.
Discovery is complete.
Discovery is complete.
People have their witnesses available the 11th.
That should be fine.
Preliminary examination in person, March 11th, 2025, 9 a.m. That is before Judge Washington.
Thank you, Your Honor.
Bond will continue.
Thank you. We'll make sure we're.
Mr. Bellinger, could you briefly approach on a separate matter?
Yes, Your Honor.
I got Polly. Court calls the case, People versus Sincere Godwin.
Mr. Public Defender Natalie Pate on behalf of Mr. Godwin, who should be present via Zoom. Sir, if you're present, can you please unmute and state your name?
Well, that's not gonna happen.
So, Your Honor, I'm kind of, well, maybe I don't have an explanation for his failure to appear. The number I had for him was his mother's. I did speak to her yesterday and she was to have him call me back. I did not hear from him. I did provide his mother with the Zoom link and I did expect him to be present. For the record, I'd request an adjournment.
Bench warrant will issue for defendant's failure to appear. Bond will be set in amount of 10,000 cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Court calls case People versus Autumn. Is it Fonte?
People.
Good morning, Your Honor. Assistant Public Defender Fellow Alexis Zerk on behalf of Ms. Fonte, who's approaching.
Wow. It's been a minute. Your name?
Autumn Fonte.
Thank you. I have before me a plea form, whichever we're doing.
Yes, ma'am. Yes, ma'am.
Plea form indicates that defendant will be pleading guilty to the charge of use of a controlled substance, that being ketamine, the 1-year offense. Upon her successful plea of guilty to that charge, count 1 would be dismissed. There's an agreement, no delayed, no deferred, no 7-4-11.
That's Anderson, going to plead, Your Honor.
May I have her sworn?
Raise your right hand. Right hand.
Sorry,
You solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name.
Autumn Rose Fonte.
All right, ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of the use of a controlled substance. Is that correct?
Correct.
That is a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. You understand that?
Yes.
All right. You also understand, ma'am, that while you're pleading, I'm taking your guilty plea, I would not be your sentencing judge and you would be sentenced before Judge Barr in the 14A2 District Court.
Right.
Okay. Understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Right.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Right.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, Your
Has
Honor.
anybody promised you anything other than what's been stated here today to get you to plead guilty?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily of your own free will. And because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
June 10, 2023, at the location of 5 West Cross Street, City of Ypsilanti, Washtenaw County, State of Michigan. Did you have ketamine in your possession?
Yes, Your Honor.
Did you have any prescription or right to use that drug?
That's fine.
All right. And you did use it?
Yes.
And you knew what you were using was ketamine?
Yes.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
The people are satisfied.
Defense is satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report, as well as screening and assessment, are ordered at 14A2 District Court. Sentencing in this matter will be
March 12th at 11 a.m. for Judge Barr.
March 12, 2025, 11 a.m. Judge Barr.
And Your
Bond.
Honor, if I can briefly address bond.
He hasn't been here in like ages, just like barges in and wants to start doing stuff. Go ahead.
Your Honor, Ms. Fonte does recognize that she failed to appear back in October. She had been in constant communication with the Public Defender's Office and it was a miscommunication. Her test results did not get over to communications in time to show that she was in fact testing. Since then, she's run into some housing troubles. She's currently in subsidized housing. She's at risk of losing subsidized housing if she remains incarcerated. If she were to be released on a personal recognizance bond, she has plans to stay in the area. She has some friends she can stay with. She believes she'll be able to test now because it is cheaper to test at community corrections than it was to test up in Traverse City. And that was the main reason and burden of her not being able to test. She also has some health concerns that she wishes to get out to be able to go to doctors and address that. She explained to me she has an infection in her chest that needs to get looked at. And
CMH here.
and she is looking back up with CMH. So she's planning on staying around to get the services that she needs with CMH as well. And if the court is concerned about her appearing at future court dates, she'd be willing to go on a GPS tether.
Response.
In large part, I trust the court and just leave it in your discretion. The only part I wasn't clear on was if she resides in Traverse City and is at risk of losing her housing in Traverse City, why would she stay local? She said she could stay local with friends, so that was the only part that didn't really make
Yeah,
sense.
it did
But
make sense.
in general, she has pledged of misdemeanor, so I'll leave it in your discretion.
Your Honor, so she would stay around here to resolve this case, and then she'll be able to have contact with her son, who resides at the apartment with her, and she will be able to help him via the phone to get the situation rectified. She has a caseworker working on the case as well, so she'll be able to maintain contact with him, so that would assist in the housing situation as well.
I still not understanding the housing situation.
She has unpaid rent and she has a caseworker who's working on it, but he was not able to contact her because she was incarcerated. So if she is out and released, he will be able to talk to her, talk to her son, and get a situation rectified.
That typically is not how it works, especially if there's somebody else at the unit. They can still deal with part of that. If they know she's in custody, they can get through to contact her if they need to. We have to do it all the time in our house.
Your Honor, I'm just going based off of what.
I know.
Communicated it to me.
Oh, I know. I mean, I realize that. Motion for bond reduction tonight, bond will continue. Thank you. Court calls case People versus Benjamin Detlefs.
Dr. Lonnie.
Stephanie Can on behalf of Mr. Detlef. He should be on Zoom, Your Honor.
Detlefs.
Your Honor, it does,
Where?
he's not here.
He's in the jail, Your Honor, but he is level 1. Last time I checked, he was.
Oh, he was
very
down in
excited.
the jail.
He must have dropped.
They dropped.
I'll take it
Okay.
back, yeah, and watch for them again.
All right. Court does call the case People versus Joel Helm-Mormon.
Stephanie Can on behalf of Mr. Held Borman.
State your name. Joel Helm-Mormon. Thank you.
Your Honor, my client has asked for a preliminary exam to be set. I've gone over discovery with him. We do believe it is complete.
You will have their witnesses available the 11th.
I'll do my best, Your Honor.
Preliminary examination in person, March 11th, 2025, 9 a.m. That's before Judge Valvo. Bond will continue.
Thank you.
Court calls case People versus Charles Carker.
Yeah, okay. Good morning, Your Honor. May it please this honorable court, David Burgess on behalf of Charles Carker, standing to my right. Your Honor, I recently received this appointment. I still need to get discovery and review of my client, so I'm asking for a adjournment of 2 weeks.
Your name?
Charles Parker.
Probable cause conference will be adjourned March 13th, 2025, 9 a.m. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls case of the People versus Micah Jones.
Assistant Public Defender Natalie Pate on behalf of Mr. Jones.
They're not.
He is in custody.
Everybody else in custody? Micah Jones.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Jones, who is approaching. State your name for the record, sir.
Michael Jones.
Thank you.
Thank you, Your Honor. I have discussed this matter with the people as well as Mr. Jones. We're respectfully requesting a brief adjournment to receive the video discovery. I do believe, frankly, our office might have received it already this morning. So
March 13th,
Thank you, Your Honor.
2025, 9 a.m. Bond will continue. Court calls case People versus Marquise Hankey.
And on behalf of the people, Your Honor.
Good morning, Your Honor. Attorney Kevin Basant, P 71061, on behalf of Mr. Marquis Hankey. Mr. Hankey, state your name for the record.
My name is Marquise Hankey.
All right. And Judge, we're asking for an adjournment. I just got substituted into this matter yesterday, Your Honor, and we're asking for an adjournment for discovery.
That's fine, appropriate.
Adjourned matter March 13th, 2025, 9 a.m. Yes, that's the bond.
Your Honor, I'm not sure, is the court in receipt of the bond violation report?
I am not.
I have not reviewed it either, Judge, but I'm certain what it would say, but.
Your Honor, I have a report from February 24th of 2025 that the defendant had absconded from his tether and had been unable to be located. And they stopped supervision. I also wanted to address his jail before he got out.
Do we have that?
No, we do not.
And you're aware of this?
I am, Judge.
And I also want to address his jail calls from before he was released.
Yes, go ahead.
In those calls, the defendant contacts a third party who then contacts the victim. The defendant says, I need you to do me a favor. So you have that number right, and the person says, whose number? He does, who is the victim. He says, I can't say the name, I can't tell anything, but I need you to do me a solid. He said, okay, what? Tell them I'm thinking of you. And he says, the defense says, y'all been talking, right? He says, no, I've only been talking to you, the victim. He says, can't see that name on the phone, because she's my case. And then in the next call, the defendant gets her added to the call. He calls the third party who then connects her to the call, and they're talking. And I also have concerns that he'd be contacting her at a different number because I had a note from Detective Mosher that he had been contacting her as well as a different number. I'm just not sure exactly what that number is. And given the facts of this case, I'm extremely concerned.
And may I address all those issues, Your Honor?
Yes.
And so briefly, Judge, my client
Just so that I know, currently right now, he was ordered on a tether and he's not on a tether right now.
Absolutely not, Judge, and I'll address it. So Judge, if I may, so Mr. Hankey, he's 22 years old, Judge, has no criminal history whatsoever. This is his first ever contact with the law. Literally, Judge, 3 days ago, he admittingly cut his tether off. He got overwhelmingly scared. He didn't understand what he was actually charged with. He thought he was charged with a life offense. I told him, no, it's a felonious assault. He was under the impression that he was immediately going to prison today because he didn't understand the law. And so he freaked out, Judge, and he indeed, admittingly, he cut his tether off. I immediately spoke with my client. I told him not to run, not to go anywhere, to address the court and to be upfront about it. And so, Judge, he's here today. He had every opportunity to not be here today, every opportunity to run, and he didn't. He takes full ownership for cutting that tether off, Judge. If I had talked to him before he did it, I don't think it would have ever happened. But Judge, I don't think he did it intentionally to, flee from the court. I believe he did it, honestly, Judge. And hear me out, Judge. I think this is a situation, Your Honor, where fear got the best of him, anxiety got the best of him. In terms of the jail calls, Your Honor, I would.
Do we have the tether back?
Your Honor, I'm not sure, but I did also want to address that the defendant does have a juvenile adjudication for a CSE fourth and a dismissed DV from 2022, which the victim failed to appear as well.
Judge, community corrections have the tether back, and there's been communications with the tether agent and the office. And so, Judge, in terms of the jail calls, I was just made aware of those this morning. I would note that his the complainant in this case is his girlfriend. She's currently pregnant. I told my client to have absolutely no contact with her whatsoever per the bond conditions. And so, Judge, I make this argument, Your Honor, because honestly, I'm asking the court if they would give him a second chance. It was a $70,000 cash surety bond. That bond was posted. But for his actions 3 days ago, Judge, we wouldn't have this bond violation, at least with the tether. With the phone calls, Judge, again, I'm not saying he admits or denies that, but he knows he's not to have any contact, third-party contact with the complainant, and that will continue. And so, Judge, I'm asking if my client could have a second chance on this tether. Again, Judge, he could have been like everyone else and just not come back or got caught.
We would have got him. I mean,
And you stole the words out of my mouth, Judge. I said, or he could be standing here today in a green jumpsuit, and he's not. He's here today, Judge, fully accountable for his actions. It won't happen again, Judge. I guarantee it. We plan to address this case, and I'm just asking for a second chance.
Counsel, go ahead, anything?
I just would kind of reiterate the facts of this case in which he pointed an AR-15 style rifle at the victim, saying to her, "I'm going to kill you. I'll put a bullet in your head." And then on the phone call, he addresses that he knows he's not supposed to be talking with her because when the other person says, "Kia, who is the victim?" he goes, "Don't mention her. She's my case." So I have great concerns that he would still be violent.
He's playing the game. I don't play games. We don't play games here. You don't get to be put on a tether. Well, first of all, be told that you should not be contacting the victim and then finding and manipulating ways to do so. Don't do it here. Doesn't happen. Won't happen. And then when you get the grace, given the nature of the charges, to get let out, then you're running around and you decide that what the court ordered in terms of a tether, you decide you want to cut it off yourself. We don't do that either. Defendant's bond is revoked, defendant's remanded. I'll see him on the 13th, and counsel, you can give me your argument as to what I should do with his bond at that point, but right now he's remanded.
Thank you, Judge.
Court does call the case, People versus Bryant Murphy.
Ashley Lonnie for the people.
Morning, Your Honor, may it please the Honorable Court, David Burgess on behalf of Bryant Murphy, who's appearing, standing to my right.
Your name? Brian Murphy. Thank you.
Your Honor, we did receive discovery in this matter. We are requesting a preliminary exam in this matter.
People have their witnesses available the 11th.
We will try, Your Honor. I have not had recent contact with my police officers, as it appears that the person's been on bench warrant for a couple months, but we'll try by that date.
Preliminary examination in person, March 11th, 2025, 9 a.m. That's before Judge Washington.
Your Honor, may I address the issue of bond briefly?
Sure.
Thank you, Your Honor. Your Honor, my client did fail to appear. He was going to go to community corrections and he knew he was going to test positive. He got scared. No excuse, Your Honor, but he did in the interim, Judge, he did reach out to me. I actually emailed the court to try to do a warrant recall. So he did make efforts he did retain counsel in this matter, but he did make efforts to come back to court to deal with this matter recently, Judge. I did not obviously get that. He was picked up in the interim before I received a response on the email, which was denied. But Your Honor, it's non-assaultive crime. There's no victim here. I'm asking the court, he has been in custody since last Sunday night, Judge. And I know he will appear for all future court dates, Judge.
Really?
Your Honor, may I respond?
You really know he's going to?
No, I don't think you need to probably, but it's okay.
Yeah, no, that's fine. Go ahead, Mr. Burgess. I'll let you finish and then I'll hear.
Your Honor, and again, he was originally on a PR bond. I'm asking the court to at least consider a 10% bond. He's currently on remand, Your Honor.
And Your Honor, it does appear to me that at the time this case came up, the defendant had a tether on and he had a violation with that tether because his battery had gotten too low. The police made contact with him. He had bench warrants for failing to appear, and a bench warrant for failing to appear on an assault battery. He had a bag of drugs on his person. It was just under a gram of cocaine, 0.88 grams of cocaine. He has a significant history for delivering or manufacturing narcotics. 2023, reckless. Looks like it was a fleeing third degree that was dismissed for fleeing. 2015, delivery, manufacturing narcotics. 2013, delivery, manufacturing narcotics, 5 counts. 2013, delivery, manufacture narcotics, 2 counts. 2014, delivery, manufacturing narcotics. 2004, fleeing third. 2004, armed robbery, and assault with intent to rob while unarmed.
Yes, for sure.
No, yeah.
Motion for bond reduction is denied. Bond will continue. Thank you. Miss Zenda, on that other matter, if you could contact opposing counsel, the one we just had before, I'm also ordering his phone privileges revoked. Court does call the case People versus Charles Humes.
And public defender fellow Nicholas Bukovich on behalf of Mr. Humes, who is approaching. Mr. Humes, please state your name for the record.
Charles Humes, thank you.
Today, Your Honor, will be waiving a preliminary exam. I do have a preliminary exam waiver right here.
Waiver.
Yes.
Is that correct? So you're waiving preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
And you understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
All right. People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendant is bound over to circuit court on both counts.
We waive the formal reading of the charges and stand mute.
Defendant having waived formal reading, standing mute as to both counts. Court will enter a not guilty plea. Pretrial will be set for April 22nd, 2025, 1:30 before Judge Conkey. We'll continue.
April 22nd at 1:30.
Court calls case People versus Sheena Morris.
And Assistant Public Defender Tanaka Carrie Your Honor, on behalf of Ms. Sheena Morris, seeing Ms. Cochran, Ms. Morris, state your name for the record.
Sheena
please.
Moore.
Thank you.
Your Honor, we respectfully request that this matter be set for preliminary examination.
All discovery is complete.
To my understanding, Judge.
People would have their witnesses available the 11th. Preliminary examination in person will be set March 11th, 2025, 9 a.m. before Judge Valvo. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls case People versus Victor Jefferson.
Ashley Lonnie for the people.
Assistant Public Defender Jay Bell on behalf of Mr. Jefferson, who approaches. Can you please state your name for the record?
Victor Jefferson.
Go ahead.
And Your Honor, I have submitted the finding an order on competency in this matter.
Yes. Is he undergoing treatment at?
Your Honor, he is not undergoing treatment officially with regard to a petition. He's not, as far as I'm concerned, working with CMH or anything. I will let Ms. Londy take over from here, though, in terms of.
Go ahead.
That's correct, Your Honor. My understanding is that the nature of the finding of incompetence relates to dementia.
Yes.
And so it may not be effective to have an order because of the degenerative nature of the disease. So I request an adjournment at this time so I can go over that within my office. We have about 30 days to make a determination as to the direction.
Right.
Well,
Well, I will sign the order.
right, yes, I'm sorry.
And then I will adjourn this out. I guess I'll still call it a competency hearing. You want a 30-day?
I would, Your Honor, please.
And Your Honor, if I may request, and I understand if this request is denied, if the prosecutor's office does decide to do a nully, and they contact me about that, and that is the direction they're going in, if I could not have Mr. Jefferson back in court, if that would be okay?
Yeah, I get it.
I have no objection to that, Your Honor. We just need a little bit of time to look at it, make sure we're doing the right thing.
March 27th, 2025.
Thank you.
Thank you. Bond will continue. Thank you.
Be all set, okay? I'll be in contact.
He is. Court does call the case, recall the case, People versus Benjamin Detla.
That's the lobby for the people.
And on behalf of Mr. Dallas, please should be appeared by Zoom. Mr. Dallas, can you please state your name for the record?
Yes, Benjamin Jim, hello, Your Honor. Your Honor, maybe you
Hello.
go to the breakout room first?
I'm sorry?
Can I go to a breakout room with my attorney?
Well, I can't put you in a breakout room where she is in person and you're not.
And I can come see you after.
So after we're done, she's indicating she'll come see you.
Can I just talk to her real quick?
What?
Can I talk to, can I speak to her real quick?
You guys are in debt. You guys are very different.
Your Honor,
She's in the courtroom.
I know.
You're not.
Personal recognizance, did you get my message about the personal recognizance bond, 70?
I understand that you want to be released on bond, Mr. Detlef. Yes.
Yeah, the personal recognizance bond. That's all I wanted to say, Your Honor. I'm sorry, I apologize.
No, it's okay. It's okay. I get it. So what are we doing?
Thank you, Your Honor. Last week, the court was kind enough to forward me information regarding my client's current evaluation as to competency. And based on the document tendered to me on that day, signed by Andrea Zenbra, I believe. Mr. Detlef is not competent to stand trial, but they do believe he is likely to attain competency if provided the appropriate amount of treatment. Your Honor, we would stipulate to those findings.
People would also stipulate to the findings have no further evidence.
All right.
Yes, court signed any proposed order of continuing treatment.
Based upon a review of that report, the defendant at this time is incompetent to stand trial. I will set a competency review hearing May 22nd, 2025, 9 a.m.
Thank you, Your Honor.
Your Honor, and I believe the court has heard from my client where he is asking for a personal recognizance bond. I'm speaking to my client. He just wants to get out and start receiving some mental health treatment, and he is just asking the court's indulgence to allow him such treatment options.
Please, Your Honor.
Until something's in place, I'm not gonna change the bond. This bond will continue. Once something's in place, I will be more than happy to look at it again.
Thank you, Your Honor.
Right?
Look into treatment for me, if I buy some treatment options for me.
Okay, what, Mr. Detlef, what you're gonna have to do is talk to your attorney about any requests that you're making. And they know the proper form to get it to me in. I'm not saying I won't look at it and won't release you, but there has to be something in place prior to my doing so.
Thank you, Your Honor.
Thank you. I'll make sure, Ms. Cannon, get those orders into me, please.
Yes, Your Honor.
Court does call the case of the People versus Corey Peters.
Echelon for the people.
For the judge. Court shall Feaster, Assistant Public Defender, on behalf of Mr. Corey Peters. Mr. Peters, please state your name for the record.
Corey Paul Peters.
Thank
you, Judge. I believe our discovery has been exchanged. And Peters is requesting an preliminary examination, please.
People have their witnesses available the 11th.
Your Honor, the people would request if we could go one additional week beyond the 11th. And I don't normally make those requests when someone's in custody. However, in this case, the victim is homeless and many of their belongings were destroyed in the arson. So I reached out to Ann Arbor to try to get a hold of them. So I would ask for the 11th, so we have a little bit more time to try to track them down. So we do not have any current phone or email information for them.
Obviously, Judge, my client is in custody. He wants the soonest possible date, but we understand the court has to make a decision.
And given it, is there nothing else holding him?
No, Judge.
It's the only thing holding him?
He might have I don't know if they violated him.
I don't know if there's been a probation violation filed, but I do know that the defendant was on probation for 4th-degree arson through the circuit court at the time of this offense.
I think it was still Judge Conlon. I have not seen, that's where I'm assigned. I have not seen the violation come through. So
Nor have I.
as far as I know, this is the only thing holding him.
Even though these charges are 2nd degree?
That's correct, Judge.
Yes, Your Honor.
Well, then it's likely to come through. I don't think there's going to be much prejudice once that comes through to the defendant. He would be held in any event. I'm not changing his bond. Also, given what the people have said, that it may be the defendant's actions which have caused their problem in getting their witnesses located. The court's going to find good cause. I'll set preliminary examination in this matter for March 18th, 2025, 9 a.m. That is hearings in person before Judge Moore.
Thank you very much, Judge.
Bond continued. Thank you. Court calls case People versus Quincy Jones. This is a one, right? No, you're not gonna find it, Jazz. I know.
Mike Gaddy, Assistant Public Defender for Mr. Jones, who's here to my right. State your name, Mr. Jones.
Quincy Frank Jones.
All right.
Your Honor, I'm asking for a brief adjournment in this matter. I did meet with Mr. Jones briefly this morning. We have scheduled a meeting in person at my office next Monday. I'd ask that be adjourned so I can go over the
Council approach on this. In this matter to the 21st, or not the 21st, to the 13th.
Thank you, Your Honor.
2025, 9 a.m. Bond.
Thank you.
Court calls case People versus Michael Strayling.
And on behalf of people.
Ashley Moten, Assistant Public Defender, on behalf of Mrs. Sterling.
Michael Strayling. Thank you.
We are requesting to set this matter for a preliminary exam. I do believe all discovery has been submitted.
People have their witnesses available on the 11th.
I believe so, Your Honor.
Preliminary examination in person, March 11th, 2025, 9 a.m. That's before Judge Valvo. Bond will continue. Thank you. Court calls case of the People versus Craig Manor.
Sophia Courier here on behalf of people. And Public Defender Fellow Nicholas Puckovich on behalf of Mr. Manor, who is appearing via Zoom. Mr. Manor, can you please unmute and state your name for the record?
Craig Manor, you'll need to unmute, turn on your camera.
Yes, Craig Manor Jr.
You need a camera.
There he is.
That's it. Okay. All right, what are we doing?
At this time, Your Honor, I'll be requesting a brief adjournment. I did receive an offer from the prosecutor this morning, but I haven't had time to discuss it with my clients.
Probable cause conference will be adjourned March 13th, 2025, 9 a.m. Bond will continue, and I'll need a green sheet, counsel, if you got one.
Mr. Manor, I'll be reaching out to you soon, okay?
Thank you. Calls case People versus Darnell Taylor.
Alexander, on behalf of people, Your Honor.
And good morning, Your Honor, Assistant Public Defender Chinazi Kyriak, on behalf of Mr. Darnell Taylor, who is approaching. Mr. Taylor, state your name for the record once you reach the podium.
Darnell Taylor. Thank you.
Your Honor, we respectfully request that this matter be set for preliminary examination.
All discoveries complete.
To our understanding, Judge.
People have their witnesses available the 11th.
We'll do our best, Your Honor.
Preliminary examination in person, March 11th, 2025. 9 a.m. before Judge Washington. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls case of the People versus Hunter Marshall.
Alexander, on behalf of people, Your Honor.
Judge. Torshell Feaster, Assistant Public Defender on behalf of Mr. Marshall. Mr. Marshall, please state your name for the record, please.
Hunter Marshall.
Thank you, Judge. I spoke to my client. My understanding is that he's requesting a preliminary examination. I do believe all discovery has been exchanged.
People have their witnesses available the 11th.
We'll do our best, Your Honor.
Preliminary examination in person, March 11th, 2025, 9 a.m. That is before Judge Valvo. Bond continued. Thank you.
Thank you very much, Judge.
Courthouse case, People versus Jeremy Walter.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Walter, who stands to my right. Please state your name for the record, sir.
Jeremy Holdsworth Walter.
Thank you, Your Honor. As to the PCC, we are respectfully requesting to set this case for preliminary examination.
All discovery is complete.
To our knowledge, yes, Your Honor.
People have their witnesses available the 11th.
We'll try, Your Honor. Thank you.
And when
Preliminary examination in person, March 11th, 2025, 9 a.m. That's before Judge Washington. Thank you. I'm sorry. Washington. Bond will continue.
Thank you, Your Honor. May I briefly make one brief round, Your Honor? Thank you. I have discussed this matter with my client. As Your Honor is aware, was remanded last week for a bond violation. At this time, and I did briefly mention this to the people, we're requesting that Mr. Walter be allowed to be released to inpatient treatment while this case is pending.
I'm not going to have a problem with that. If you prepare the order, I'll sign off on that.
Thank you very much, Your Honor.
Otherwise, it's bond will continue.
Thank you, Your Honor.
Courthouse case, People versus Keisha Melchor. She was on there.
Hannah Mackey on behalf of Mrs. Melchor, who is appearing via Zoom. Mrs. Melchor, please state your name for the record.
Keisha Melcher.
Melcher. They're requesting an adjournment. There's a request for a 1 month adjournment. Any objection from the people? Okay. Probable cause conference in this matter will be adjourned March 27th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you, Your Honor. Have a
Thank
blessed
you.
day.
Take care. You do the same.
Thank you.
Courthouse case, People versus Charles Williams.
Ready, Judge? Portia Feaster, Assistant Public Defender on behalf of Mr. Charles Williams. Get here. State your name for the record.
Charles Devon Williams.
Thank you, Judge. I have met with Mr. Williams and emailed the prosecutor. We are just requesting an adjournment of today's date to see what we can work out in terms of potential resolutions.
March 13th, 2025.
Thank you.
9 a.m. Bond continued.
Thank you very much, Judge.
Courthouse case, People versus Michael Primus.
Public Defender Fellow Nicholas Partridge on behalf of Primus.
Andrew Phillips on behalf of the people.
Mr. Primus should be appearing via Zoom. If you can unmute and state your name for the record.
Mr. Primus. All right, you need to turn your, oh, go ahead. You're good.
Michael Primus.
All right, what are we doing?
At this time, Your Honor, we are requesting to set this matter for preliminary exam. To my knowledge, all discovery is complete.
People have their witnesses available the 11th.
Go 1 week past that.
Any objection for the defense?
No objection, Your Honor.
Preliminary examination in person, March 18th, 2025, 9 a.m. That's before Judge
Barr.
Judge Barr. Bond continue.
Thank you, Your Honor.
Thank you. Courthouse case, People versus Michael Horn.
People.
Signed in on Tuesday after jury selection, but then let Emily know he was signing out. In Zoom or press back.
Right.
Portia Feaster, Assistant Public Defender on behalf of Mr. Michael Horn. Please state your name for the record.
Michael Horn.
Your Honor, my understanding is that our office was due to a conflict. Has the court received that information yet?
I don't know that I've received I have a substitution of attorney, which I've not signed off on, that Kareem Johnson is going to appear. He signed on. He said he had to go to jury selection and into a jury trial.
Okay.
So
That's for an adjournment so that Mr. Johnson could be present at the next PCC, Your Honor.
sir, did you retain Mr. Johnson or?
He was paid, yeah.
Oh,
He was paid, okay, that's why I have a substitution, I get it.
okay.
But I don't. Okay. The form that I have for substitute, I don't have the PD signature on.
Okay.
So you guys are gonna have to work that out. So since your attorney's not here, I'm gonna adjourn it out a couple weeks, okay? All right,
Thank you, Judge.
thank you. To the 13th, 9 a.m.
Thank you, Your Honor.
And Judge, I have spoken to my client. He does want Mr. Johnson to be his attorney, so I can come and sign that if the court wants me to do it now. Thank you, Judge. All right, you can go with that.
Thank you, sir.
Thank you, Judge.
That was the last end. Court calls the case People versus Cynthia Solomon.
Good morning, Your Honor.
Public Defender Jay Bellinger on behalf of Ms. Solomon, who appears beside me. Ms. Solomon, can you please state your name for the record?
Cynthia Solomon.
We have 2 plea forms.
That's correct, Your Honor. We also have an advice of rights.
Yes, I do have.
And
that.
there's a waiver form as well, Your Honor, should we need one for the child abuse charge. It's the High Court misdemeanor.
The High Court.
Correct.
Hold on, hang on a second. I have both of these cases at 1 year.
Oh, am I mistaken?
I'm sorry, I couldn't hear.
He said he has both cases at 1 year misdemeanor.
That is my bad, Your Honor. I apologize.
I thought, okay, I thought the embezzlement.
The
That's-
embezzlement should be.
A 1 year.
1 year. The child abuse.
This is a 2 year.
Right.
And that one I would likely just send up and let the plea be taken off.
Yep, that's absolutely fine, Your Honor. We did do the waiver for that.
Okay, and you did the waiver for it.
Correct.
Okay. So ma'am, on case ending in 1006, you're waiving your right to a preliminary examination?
Yes, sir.
All right, you understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
All right, you understand that you will not have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
All right. People also waive their right on that case. Preliminary examination having been waived, defendant bound over to circuit court on the single count. Mr. Ballinger.
Oh, Your Honor, I'm sorry. As to that, we acknowledge receipt of information, wait formal reading, stand mute. It's been a minute since I've done a waiver.
Standing mute, court will enter not guilty plea pretrial in that case set for
April 22nd.
April 22nd, 2025, 1:30 Judge County.
Your Honor, I'm just being informed by my client that she's supposed to be induced on the 23rd. So, I mean, I can always ask up in the circuit court whether we can move that date. That's fine.
So, hold on. You're supposed to be reduced to 23rd of April?
Yes, sir. And I have to be in the.
So this is
hospital
the
the night-
22nd. So you go to court.
She'll have to be in the hospital on the 22nd, Your Honor.
I know how it works.
I don't.
Thanks.
I'm not, listen.
I'm joking. And you're like, oh, she has to be there. I get it. I get it, counsel. I know.
All right.
Goodness gracious.
Your Honor, I don't know how many.
So what I will do is I will set it for that date.
Okay.
You'll need to move it.
No problem.
No problem. I'm sure they'll not have a problem.
Thank you.
All right. So bond will continue in that case.
Thank you.
On the other case, may I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God? State your name.
Solomon.
All right. Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of embezzlement by an agent or trustee, 200 to 1,000. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. The fine could be increased at 3 times the value of the property taken. If that's greater than $2,000, that becomes the maximum fine. Do you understand that?
Yes, Your Honor.
Understanding all that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
There is also, I should say, as part of this agreement, that there's a global resolution with 25 FB 1006, which is the other matter, and that restitution is $1,200 to minors. All right, everybody.
That is our understanding.
All right. I don't know where I was. To that charge, how do you plead?
Guilty, Your Honor.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any questions regarding any of those rights?
No, Your Honor.
All right. Please look at paragraph 5. You'll see it on the podium. Those are your rights which are part of the trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that.
Yes, Your Honor.
You understand you're giving up your right to a bill of rights.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
Between the dates of November 20th, 2021 and December 5th, 2021, location of 3825 Carpenter Road, that being the Meyer store, Pittsfield Township, Washington County, State of Michigan. Were you an employee there?
Yes, sir.
All right. What was your job?
I was a cashier.
Okay. What happened that makes you think that you're guilty of this offense?
I took money out of the cash register, trying to have my daughter's birthday party.
Okay, so you took money out of the cash register and converted it to your own use?
Yes, Your Honor.
All right. And you took more than, over the period in time, you took more than $200?
Yes, Your Honor. 1,200.
Okay. And you didn't have anybody's permission from Myers
No, Your Honor.
to do that? And it seems like an obvious question, but part of the elements, you came into possession of that property by virtue of your employment?
Yes.
All right, counsel, have I applied with the court rule? Would it be proper to accept this defendant's plea?
Satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation, pre-sentence investigation is ordered. Sentencing in this matter will be April 23rd, 2000. Bellinger didn't even get it. Anyway,
I got it.
It won't be April 23rd. Because she'll be in the hospital that day, Bellinger.
Yes, she will. She'll be given.
It'll be March 12th,
She'll be given birth.
2025, 9 a.m.
Thank you, Your Honor.
It'll be March 26th at 1? Why? Oh, she's out of custody? So I should put her in custody and keep the...
No.
What? Was that what you said? Emily was saying I should put her in so she can have this day.
I don't believe Emily was.
That, absolutely. That's the communication I got. March 26th, 2025, 9 a.m. That is before me. Is that right? Or 1 p.m.? Okay, she's changing times too. 1 p.m. And that's before me.
Thank you, Your Honor.
Your Honor, may I send the information on the
Alan took it. I think, yeah. I don't. Yes, you may. But what'd you do with the file, man?
We will get you where you get into custody. All right. 22nd for your pre.
What?
Judge Conklin Court.
That's a plea. And then the other one that.
March 26th at 1 a.m. here.
Court calls the case versus Kirby Snyder. Why don't you smile?
Assistant Public Defender Ashley Bashir on behalf of Kirby Snyder, who is approaching.
Your name?
Kirby Snyder.
Thank you.
You're welcome.
All right, what are we doing?
We're seeking a brief adjournment for mitigation. There's a mitigation report that's being completed for consideration by the people.
No objection.
All right. How much time did you need to get that?
I requested 2 to 3 weeks. I think 2 weeks.
Probable cause conference, March 20th, 2025. I need the green sheet. Ron, can-
Thank you.
Thank you. Thank you, ma'am. Or calls the case of, recalls the case, people versus the Sean Courtright. You're leaving for the day? Come here for a second. Counsel, approach. You better bring a supervisor because you're in trouble. To work with you on everything that I've tried to work with you on.
I had just got out of
Point.
jail. I didn't have money. I don't have money for that. If I go to jail, I'm gonna lose my housing. I've been kicked out of therapy. Everything that it was helping, I've been kicked out of. I'm not able to attend my women's trauma group because I had court Wednesday. I had just got that started back after a year. I see my baby. I haven't seen her in 6 years going through this court stuff, them sending stuff to the wrong address. My baby gonna be 18. I don't have a natural parent child bound
Every
with my
case
daughter.
before me, I've tried to work with you. I have.
I'm just not getting the
appearing
paperwork.
on certain things. I've done everything I possibly can to try to facilitate the process for you.
If somebody
But I
pays
can't,
for it, I don't
if you
have.
want to keep interrupting me, you can keep interrupting me, but it's not gonna get you. But the cold hearted reality is that when you're given bond conditions, you have to comply. You can't just go over there and say, I'm not gonna do it.
I didn't say that. I called my attorney and spoke with him and voiced my concerns with that. I'm physically not able to do that. I have issues, health issues with that.
Well, it's gonna have to be
And
addressed.
I
before
can't
Judge Valvo
physically-
regarding her release. Defendant's bond is revoked. She's remanded to the Washington County Jail.
Excuse me, I'm gonna lose my housing, like, my rent and stuff is due. Well, can we talk again? Cause I didn't talk about this with you, Mr. Lucas. I got rent coming up. I'm gonna lose my housing. I can't see the daughter. What is this about? Like, what did I do? Please say something before I come back.
All righty then. 14A will stand in recess. Court does call the case of the people versus Javon Smith.
Andrew Childers appearing on behalf of the people.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Smith. Mr. Smith, please state your name.
Giovanna Smith.
Your Honor, oh, go ahead. Sorry.
Just by the way, back to court recalls, this was a case that was getting adjourned because of a delay in medical records.
Yes.
We've actually gotten to the bottom. We don't have the medical records yet, but we figured out why there was a delay. And it turns out there had been communication sent from the medical record company, because it really wasn't the hospital, to the original OIC who's been out on long-term leave. There is an acting OIC who's been my point person. He didn't receive this communication. When this individual who we're trying to get the medical records for, who was not a minor, was admitted at the hospital, he was unconscious, and there was a question of whether or not he would survive. So his parents signed off on the original release. He survived, but is not a minor. So the hospital now needs him. So we figured out why the delays existed. Our victim advocate's been working with Officer Wells from AAPD about getting that release. So we expect that we should be able to obtain these records now, but that's why.
Now that all of it, got it, that all makes sense in a way. So you need an adjournment.
Please, Your Honor.
And so how long will it take now that we cleared all of that, or at least know what it is?
I mean, I think maybe we come back in 4 weeks would be my thought, 3, 4 weeks, something like that.
That's fine with me, Your Honor.
Probable cause, March 27th, 2025, 9 AM, or as your invite indicates, bond will continue.
Thank you.
Court calls the case of the people versus Desiree Walker Johnson.
Andrew Childers appearing on behalf of the people.
Good morning, Your Honor, or afternoon. Hannah Mackey on behalf of Miss Desiree Walker, who is approaching to my right. State your name for the record. Desiree Walker.
All right.
Your Honor, at this time, we would like to adjourn the matter of 3 weeks, 4 weeks,
4 weeks. Why are we adjourning so long?
awaiting a mitigation report from AIM, Your Honor.
Probable cause conference, March 20th, 2025, 9 AM. Bond continued.
Thank you, Your Honor.
Thank you. We're up at the front, I take it.
I have a sticker.
They gave you a little sticker. Oh my. Court calls the case, people versus Sean Newcomb.
Excuse me, Sophia Curry.
Newcomb. Pardon? Bench warrant will issue for defendant's failure to appear. Bond will be set the amount of $10,000 as surety. That warrant will issue immediately. Court calls case people versus Gabriel Steffen.
Sophia Curry, appearing on behalf of the people.
Is this the one? But is that the co-defendant too? Next one. Pardon?
Yes.
Okay.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Stephen, who stands to my right. Please state your name for the record, sir.
Gabriel Alexander Stephen.
Thank you.
Thank you, Your Honor. I did receive an offer from the people this morning, which I did discuss briefly with my client as well as with the people. We are asking for a 2-week adjournment so I can have a fully informed discussion with my client about this. I believe the people stated they would keep the offer open until that time.
That is correct, Your Honor.
March 13th, 2025, 9. Bond continued.
Thank you, Your Honor.
Thank you.
Thank you. Court does call the case of the people versus Mizuko Ozawa.
Sophia Curry, appearing on behalf of the people.
Good morning, Your Honor. Rob J. Kill on behalf of Ms. Osawa. State your name for record. State your name.
My name is Mizuki Ozawa.
Judge, we're waiving the interpreter. It's my understanding this case is going to get dismissed.
That is correct, Your
Honor. Okay, case is dismissed. Case dismissed. Thank you.
Thanks, Judge.
Thank you.
Madam Interpreter, thank you very much.
Communicate with her in the chat.
Okay. Oh, she unmuted and then came back. Court does call the case of the people versus Christopher Willis.
Andrew Childers appearing on behalf of the people.
Edward Lucas on behalf of Christopher Willis. Christopher Willis.
Yes, what are we doing?
Your Honor, I was just appointed to this case. I understand there's some video in the matter. I'd be requesting an adjournment to obtain.
Probable cause conference will be adjourned March 13th, 2025.
Thank you, Your Honor.
9 AM bond continued. Proposed case of the people versus Stephanie Martin.
Andrew Childers appearing on behalf of the people.
Good afternoon, Your Honor. Dan Guerin on behalf of Stephanie Martin, stepping forward. Deputy, state your name.
Stephanie Martin.
Your Honor, we're asking for an exam date, but there is a travel request. If we can make that before Your Honor sets the date. I'm going to take what I consider like a half-court shot to see if you'll permit travel. I don't know if you'd be okay with that.
Do what?
What?
If I would what?
What? Just seeing maybe a Hail Mary, right, Mr. Childers, something?
How about a little longer than a half?
Taking a shot in the dark as whether you'll allow travel.
You know, I despise Spartans, and there are two of them standing before me. So she's not going to travel?
No, she's not a Spartan.
And I'm just
She
gonna give
she shouldn't be.
I know, she picked you.
May have been a mistake.
Wow. I mean, didn't even get out of the gate, just started. And I said, no one where I have control over something is going to say anything.
Can't believe Mr. Childers hasn't had his opportunity yet.
No, Mr. Childers has been nothing but a gentleman for that lucky win that they had. You, on the other hand? All right.
Ms. Mark, can you tell the judge where you're hoping to go?
And I'm going to tell you why I can't grant it. No, go ahead. No, Ms. Mark, tell me.
My family lives in Florida and my niece was recently born. You had approved of travel for me it would be last week.
Yes,
But my
ma'am.
entire family got sick with influenza A, so we had to postpone.
Got it.
Trip.
Okay, so the travel, you were going to go February 18th to the 20th.
Correct.
All right. They did it the last time. I'll do it.
Thank you, Your Honor.
Can you give them the dates that you're looking at?
Yeah, so it would be March 10th through March 19th.
Got it. I'll indicate defendant can travel to Florida March 10th through the 19th. Then that puts in the exam to the 25th.
Be fine with us if that works for the people.
Will that work?
That's fine, Your Honor.
Preliminary examination will be in person, will be set March 25th, 2025. Yes. 9 a.m. before.
Judge Moore.
Judge Moore. Judge Moore. All right. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
And put Garen on that.
I had a feeling.
Court calls the case, People versus Kevin Moore.
Good afternoon, Your Honor. Allison Castles, appearing on behalf of Miss Morgan, who's approaching to my right.
Your name?
Devin Morgan.
All right.
Your Honor, we'd ask me.
Are you a Spartan?
No,
Good.
it's better call.
Yeah.
Um,
And I'm gonna tell you something. It's nice of you to bring Garrett along. Go ahead.
Yeah, I'm trying to teach him. We're gonna ask to set this for a preliminary exam. And before the day and that, we also have travel to address. I'm not a Spartan.
Okay, all right. People know how this works. Where would you like to go?
Asking to travel to Texas from March 19th to the 24th. Departing Texas, it'll be a cruise.
It'd be a what?
A cruise.
From Texas.
Yeah, departing.
So 19th to the 24th, going to Texas, but going on a cruise and then ending up back in Texas.
Yes, and then back to Michigan, still on the 24th.
Gotcha. And that's March 19th to the 24th. All right.
Correct.
Okay. And so I can do it on the 11th.
The 11th will work. We're also able on the April 1st between those two.
She just tried to pick her day. She just. I liked her. Just don't anymore.
That's what did it.
Does the people have their windows available the 11th?
I prefer April first. All I'm thinking though is what I need to do is find myself as a client to Dan Garrett, because that might actually give me a vacation.
I see.
They all seem to be going to warm places and I'm still here.
Now I should just get up and leave. Come back and everybody waits. I'll walk back in. They can think about how they're behaving. You know, I'm going to give this to you, counsel, but at some point you're going to pay for it. You're not going to know. It's just going to come out of the blue. You will pay for it. Dana tell you.
I will or Dan will?
I'll set it for April 1st, 2025, 9 a.m. That's before Judge Washington. And I'll let her know that that's what you do. I will continue.
Thank you, Your Honor.
Safe journeys, man. Court calls the case, People versus Paul Yu.
Good afternoon, Dan, on behalf of you, should be here on Zoom.
Yes. Mr. Yu, can you state your name, please?
Yeah, my name is Paul Yu.
Thank you.
Rather, there should be a green sheet in the file. We're asking for an adjournment to get through another, it's a PPO hearing. That's scheduled on the 13th, so we could have any time after that. That would be appreciated.
Okay. The PPO is on the 13th?
Yes.
Probable cause conference, March 20th. Right, yeah, 2025, 9 a.m. Or as your invite indicates, bond continue.
Thank you very much, Your Honor.
Thank you, Mr. Yu.
Thank you, sir.
Court calls the case, People versus William Katke.
Andrew Childers appearing on behalf.
Good afternoon, Judge Alfred Harris, appearing on behalf of Mr. Katke, standing in for attorney of record Tyler Velo. Mr. Katke standing to my right.
All right. Your name?
William Katke.
All right. All right, what are we doing today?
Requesting an adjournment, Your Honor.
Discovery issues. Probable cause conference, March 13th, 2025, 9 a.m.
I got one other issue, Your Honor. Mr. Katke currently has.
Is he a Spartan?
I'm born, raised, and graduated UM.
University of Maryland?
Michigan. Go.
Well, that won't work either. All right, go ahead.
He currently has a scram tether, and we're requesting if it could be changed to a SoberLink device.
Any response from the people?
What was the request?
He currently is on a scram, but are requesting that it change to a SoberLink.
Doesn't have any violations, Your Honor.
How did he end up with, was it initially put on a scram?
Yes. At Raymond.
What's the alleged BAC in this?
Actually, it was 0.074 grams of alcohol, but also THC, 13 nanograms of THC. I will say what is noteworthy, however, is the vehicle was clocked at 135 miles per hour on US 23. Okay. But I know the courts. I don't necessarily believe that SoberLink is granting it.
Yeah, I mean, SoberLink may be actually more burdensome, but he needs to understand that if he misses a test, I'm going to consider it a violation.
I was on this the last time this charge was brought against me. I understand how it was, John.
We'll prepare a new order for switching him to a sober lane. If bond otherwise, we'll continue.
Thank you, Judge.
The 13th.
Thank you.
Court calls case of the people versus Michael Johnson.
On behalf of the people.
Judge, good afternoon. May it please the most honorable court, Vincent J. Toussaint, on behalf of Mr. Michael Johnson, present, standing to my right.
Good afternoon.
Good afternoon, Judge.
Your name?
Michael Johnson.
All right. What are we doing today?
Judge, we're asking for an adjournment. I have a medical procedure coming up beginning of March, and I would like to, I've been putting my cases off until the beginning of April.
To the beginning of April?
Yes, Your Honor.
All right. Do the people have any objection to?
No objection.
Third or the 10th work better for you?
Judge,
You're putting everything off. That first week's going to be jammed, so.
Understand.
I'll give you whatever day you want. You just tell me.
10th, Your Honor, that works.
Work?
10th will work.
Probable cause conference will be adjourned April 10th, 2020. 9 a.m., but as your invite will indicate, it'll likely be in the afternoon.
Thank you, Your Honor.
Thank you.
Judge, good to see you. It's been a long time.
Yes, it has, sir. You're looking well.
All right.
Take care.
You as well, Judge.
All right. Godspeed on your surgery. Court calls the case, people versus Livia Stevenson Howard.
Andrew Childers appearing on behalf of the people.
Good afternoon, Your Honor. Good afternoon again, Your Honor. Robert Goldman, P8 122, appearing on behalf and alongside defendant Olivia Indigo Stevenson Howard. Ms. Stevenson Howard, could you please state your full name for the record?
Olivia Indigo Stevenson Howard.
All right. I have a plea form in front of me. Is that what we're doing today?
Yes, Your Honor.
Yes. Plea form indicates that the defendant will be pleading to an added count 3 of operating while visibly impaired, the 93-day offense upon her, and also count 4, the attempted resisting and obstructing a police officer, count for a 1-year offense. Upon her successful plea to those 2 charges, counts 1 and 2 would be dismissed. It is also indicated that it's okay to seek HIDA on count. That's the court's full understanding of the agreement.
That's correct, Your Honor.
That's correct, Your Honor. That's an accurate recitation of the plea discussed with both the prosecuting attorney and as relayed to Ms. Stevenson Howard.
All right, very good. May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Olivia Indigo Stevenson Howard.
All right, you can put your hand down. Ma'am, it is this court's understanding that you're going to be pleading guilty to 2 misdemeanor charges. Is that correct?
Yes.
The first would be an added count 3 of operating while visibly impaired. That is a misdemeanor punishable by up to 93 days of jail, up to a $300 fine plus court costs. The court could order any rehabilitative services or community service the court deems necessary. The court could order your vehicle immobilized. Court order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes.
All right. Also, that you'll be pleading guilty to an added count 4 of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. You understand that?
Yes.
All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court. You understand that?
Yes.
All right. Now, understanding all of that, you still wish to plead guilty.
Yes.
Is that what you want to do, ma'am? I noticed a hesitation. You want to plead guilty?
Yes.
All right. To the charge of operating while visibly impaired, how do you plead?
Guilty.
To the charge of attempted resisting and obstructing a police officer, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form today, is that correct?
Yes.
Do you have any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium there. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights of that law.
Yes,
You understand you're giving up your right to appeal of right.
yes,
Are you on probation or parole?
no,
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
no,
Anybody threaten you or coerce you?
no,
You're doing this voluntarily
yes,
of your own free will
yes,
and because you believe that you're guilty of these offenses?
yes,
On the date of August 12th, 2024, at the location of 800 South Maple Road, City of Ann Arbor, Washtenaw County, State of Michigan, were you operating a motor vehicle?
yes,
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
yes.
What did you have and how much?
Mixed drinks.
Okay, Kool-Aid's a mixed drinks. What kind of mixed drinks did you have?
Like liquor, lemonade.
Okay, so you had liquor mixed with something else, correct? Were you stopped by the police or was there an accident?
I was stopped
Why'd they stop you?
because I went in the passing lane. Like past people,
Went in the passing lane and passed.
like the turning lane. the left
Oh, you
turn-
went in the center lane and
Yeah.
were passing people
Yeah,
on their, what would have been on their left,
yeah,
improperly so, correct? You're not challenging the right of the police to stop you, are you?
I don't understand.
Meaning, you're not saying that there was anything wrong with the police pulling you over?
No,
Okay. After you were pulled over, were you ultimately arrested?
yes,
Were you taken to the hospital or to the police station?
police
Or
station,
both?
police station,
All right, was there a blood draw or a breath test of some type?
breath test.
All right. And what were the results of that test?
0.13.
All right.
Your Honor, we would stipulate as recited in the case report as well.
All right. And so you have no reason to object to those test results, do you, ma'am?
No,
All right. Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
yes,
All right. On that same day and at that same location, obviously you came into contact with police officers. What happened that makes you think you're guilty of the offense of attempted resisting and obstruction?
what happened?
Well, what happened with your interaction with the police officers?
They tried to arrest me
Okay.
and I attempted to not
Be arrested.
arrested.
Okay, so what'd you do?
What did I do? Like
Okay, you just told me that they were trying to arrest you. You were trying to resist in some way that arrest. What specifically did you do to try to, as you're saying, not be arrested?
Your Honor, may I have voir dire, Ms. Stevenson
You may.
Howard? Ms. Stevenson Howard, when you had come into contact with law enforcement, did they ask you to exit your vehicle? And at that time, you had attempted to stay in your vehicle despite that order from the officer?
yes,
Did you engage in a verbal conversation where you had resisted being placed under arrest?
yes,
And ultimately, did the officer have to physically restrain you as part of the arrest?
yes.
Hold on, just hold on. Was your answer to the last part yes?
Yes.
Counsel, have I complied with the court rule? Would it be proper to take this, accept this defendant, please, these charges?
So satisfied, Your Honor.
Court will accept the defendant's pleas of guilty to counts 3 and 4. Counts 1 and 2 are dismissed. Pre-sentence investigation and screening assessment is ordered at 15th District Court probation. Sentencing in this matter will be March 18th, 2025, which is 9 a.m. 9 a.m. before Judge Valvo. Bond with its conditions will continue.
Thank you, Your Honor.
Thank you. First case, People versus Molly Fox.
Afternoon, Your Honor. Jacob Stanley on behalf of the people.
Ellen Dennis appearing on behalf of Molly Fox. She was here on Zoom.
Yes. Ms. Fox, can you state your name?
Molly Fox?
All right. And what are we looking to do? Adjourn this matter?
Yes, Your Honor. I submitted a written request earlier this morning because I was foolish enough to come at 9 and I just wrote it out.
It's okay.
Gave to the.
How much time did you need?
Well, I was thinking actually the 20th might be good. I could do the 13th,
Okay.
but I have a
That's
doctor's.
fine.
Okay.
The 20th will work. There's a lot that you're trying to do here, so. Without objection, probable cause conference, March 20th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you, Your Honor. Court calls case of the People versus Ahmad Holiday.
Sophia Curry, appearing on behalf of the people.
Good afternoon, Judge James Murphy, 5490, appearing on behalf of Mr. Holliday, who is present and consents to hold this matter via Zoom. Please state your name for the record.
Ahmad Holiday.
Hey, what are we doing?
Your Honor, I haven't had a chance to speak with the prosecutor on this one. Can I get their information and possibly send a deviation request to their office?
I can't understand them.
He wanted to, he says he wants to speak. Is this, you're going to be handling this case?
If he puts it on, I'm here every other Thursday.
Thursday. I think he wants to speak with you beforehand. He just needs to know.
Okay, you can email me at Curry, CURRY, as in Sam, at washington.org.
Okay, thank you. I'll be sending a deviation request to your office.
All right. I will then probable cause conference in this. I'll adjourn to March 13th, 2025, 9 a.m. Or as your invite indicates, bond will continue.
Thank you, Judge. Great day to you and your staff.
Thank you. Court calls the case People versus Osama Janed.
Good afternoon, Your Honor. Abed Hamoud, P54908, on behalf of Mr. Janed, who is seated here in my office next to my left.
All right. Thank you. And sir, can you please state your name?
Osama Janed.
Thank you. All right. What are we doing?
Your Honor, we, after speaking to the prosecutor and to my client, we would like to waive the exam, the preliminary examination, and then if and when the court permits me, I'd like to address bond conditions after.
All right. You want to waive preliminary examination?
Yes, Your Honor.
Mr. Janed, is that correct? That's what you wish to do, is to waive preliminary examination?
Yes.
You understand that that would be a hearing where the people would have to show by standard of probable cause that the offenses alleged were committed and that you committed them?
Yes.
You understand you will not have that hearing and that you'll proceed to circuit court for further resolution in this case?
Yes.
All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on counts 1 and 2.
And Your Honor, the people would not waive notice on, or a 7-day notice on the bond argument.
Pardon?
People would not waive 7-day notice on a bond argument.
Okay.
Sir, I had spoken yesterday with the prosecutor on the case, and I did tell her I'm gonna bring it up today, but fine, I understand they have the right to have the 7 days on a bond argument, and I guess I won't be able to.
What is the issue? Because usually we don't have that problem.
It's tether, Your Honor. My client is on $100,000 cash and surety bond that he posted. This case, the events took place in 2023 in October, and the charges were brought up this January. I can tell the court more about my client. He's not going anywhere. We're going to deal with the case. It's just the tether hinders him. He worked in construction. It does hinder. And if we can, he still have a cash bond that's significant. And he doesn't even know the name of the victim or where she lives. So she's on the west side of the state. So there's no risk of no contact. I did not give him her address or anything that I have from the discovery. So.
Well, I'm not going to change the condition of a tether case. I'm going to leave the tether in place. You certainly may raise that at circuit court, but I'll address it here that I'm not changing that.
I understand.
As to the arraignment, you waive formal reading of the information and your client stands mute to these charges, sir?
Yes, Your Honor, we do.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
April 22nd at 1:30 Judge Simpson.
April 22nd, 2025, 1:30 before Judge Kunke.
Thank you, Your Honor.
Thank you. Bond will continue.
Thank you, Your Honor.
Court calls the case People versus Jay Mahler.
Good afternoon, Your Honor. Lawrence Margolis with and on behalf of Mr. Mahler, who is here via telephone. Jay, please unmute yourself and state your name.
Jay County, people, Your Honor.
Mr. Mahler, please unmute yourself and state your name. He's been on all morning, Judge. He may have gone to the bathroom or something.
I'll pass it.
Okay, there he is.
Oh,
Mr. Mahler,
there he is.
can you hear us, Jay?
Yeah, this is Jay Mahler. Sorry, I forgot the code to unmute.
Thank you. Judge, today's date and time set for PCC. I've gone over my client's rights with him to an exam, and we wish to waive the exam. I believe the people.
I need visual on him if he's going to waive.
All right, we did I spoke to the prosecutor, and we are in agreement to modify, if Your Honor would be inclined to modify his bond such that he could appear for this. And there's a proposed order, I believe, that Ms. Wielding has advised she.
So he's not appearing via Zoom because he is out of state and he can't use a computer.
Correct. He can't access the internet. That's correct, Judge.
And he would, I will give him permission to do it for these purposes of, for a court proceedings.
Okay. And I wanted to make sure that that was okay with the court before I advise my client to do that. Mr. Mahler, if you can access the video Zoom link, we would like you to do that.
Okay, I will.
All right, let me pass it. He's going to try to do that now. He'll sign on and then we'll deal with it.
Yeah,
Thanks,
may I
Judge.
approach to sign the information from the previous?
Court calls the case of the People versus Mao Yang Wang.
Good afternoon, Your Honor. Uwe Daus with and on behalf of Mr. Wong Marvin. State your name for the court, please. Oh, yeah. For public cause conference, we are requesting an adjournment of 2 weeks. Parties are in discussion towards resolution. It just takes some time to get there.
Probable cause conference without objection, March 13, 2025, 9 a.m.
Very good. Thank you.
Bond continued. Thank you. Court calls case People versus Khalil Haddon.
Good afternoon, Your Honor. Charlotte Steffen on behalf of Mr. Haddon.
Your name, sir?
Kahil Jabran Haddon.
Okay.
Your Honor, would you have a resolution if I made a post turning the sign, please?
Okay.
You want to address
Get
the
it.
violations first?
Yes.
Okay.
But did you get a copy of the report?
Yes, I did, Your Honor. Thank you. And I have reviewed it with my client. He humbly is before you, Your Honor. He acknowledges that he missed his tests. He acknowledges also that he tested positive for THC. He's not bearing any excuses, but on his behalf, I do want to shed some light as to what led him, I guess, to miss his testing. Judge, I would say that he's currently somewhat overwhelmed with what's going on in his life. He's currently battling colon cancer himself. And he also recently has become the caretaker for his mother. And he didn't know until walking it out how complicated the caretaking for his mother is. So he's not making excuses, and he's regularly seeing his own doctor and providing blood tests and urine tests. And he's not just meaning to disrespect the court, but I think with what's going on in his life, the testing in this case has taken a back seat to those other issues that he's dealing with, Judge. So, like I said, he's pleading guilty to those violations. He's not making excuses, but he's not using drugs other than the THC, and he is still trying to renew his medical marijuana card. Thank you, Judge.
Anything from the people on the violation?
No, Judge.
If I were to give you a test today, would you come back clean?
Yes, I would. I can go right over to community corrections and, come back and wait for whatever results.
What I'll do is I'll take the plea, and then you're gonna need to get yourself over to community corrections afterwards, so.
Yes, sir.
Because otherwise you'll be dealing with the other judges to what's there. All right. Has he signed an advice of rights counsel?
I'm sorry, Judge, he has not. Thank you. We did go over it, Your Honor, but he hadn't signed it.
That's right. May I have this one?
Brian, you solemnly swear to affirm the testimony you're about to give truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
State your name.
My name is Kahil Jabron Haddon.
All right. The plea form that I have indicates that the defendant will be pleading to two added counts of use of a controlled substance. Both one-year offenses, added counts 3 and 4. Upon a successful guilty plea to those charges, counts 1 and 2 would be dismissed. That's the court's full understanding of the agreement. So, sir, it is this court's understanding that you're going to be pleading guilty to added count 3 of use of a controlled substance, that being cocaine. That's a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. Do you understand that?
Yes, I do.
It's also this court's understanding that you're going to be pleading guilty to an added count 4 of use of a controlled substance.
Fentanyl.
Fentanyl, all right. It's also a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. Do you understand that?
Yes, I do.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court. Understand that, sir? All right. Understanding all of that, you still wish to plead guilty?
Yes.
All right. To the charge of use of cocaine, how do you plead?
Guilty.
To the charge of use of fentanyl, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind?
Yes.
All right. You signed an advice of rights form, is that correct?
Yes.
Any question regarding those rights?
No, Your Honor.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
And because you believe that you're guilty of these offenses?
Yes.
That is nothing what I want after this. On September 21st, 2022, at the location of West Huron and 7th in the city of Ann Arbor, Washtenaw County, state of Michigan, did you have cocaine in your possession?
Yes.
Did you also have fentanyl in your possession?
Yes.
Had you used the cocaine?
Yes.
Had you used the fentanyl?
Yes.
Did you know what you were using was cocaine and fentanyl?
Yes.
All right, counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People satisfied.
Defense is satisfied, Your Honor.
Court will accept the defendant's pleas of guilty to counts 3 and 4. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
March 28th at 8:30 a.m. Judge Perry.
March 28th, 2025, 8:30? 8:30 a.m. before Judge Perry. Bond will continue. And they sent the violation, so you gave me another form.
I did, I think it's just 7 weeks out.
All right.
Check today.
How often are you testing for community corrections now or supposed to test?
It's randomly, so I usually call when I remember. I would just call and check, but like I said, it's not like a set time when I do it.
Right, but
One time weekly according to the.
Oh, okay.
one time a week. Okay, so I'm gonna order again because you violated the one time per week, and I'm just gonna indicate defendant to test today. All right, so you need to head over and do your testing. All right, that's the only sanction I'll take for the violations at this point, given.
We appreciate you very much, Your Honor.
All right, thank you.
Your Honor, he doesn't have to come back here after he tested.
No, you're good. All right, thank you. Court calls the case of the people versus Rakesh Sabharwal.
Your children's. Your Honor, Kevin Thompson appearing on behalf of Rakesh Sabharwal. Rakesh, could you state your name for the record?
Rakesh Sabharwal.
Judge, as a preliminary matter, I went to Eastern University and Cooley Law School. I am as Ann Arbor as they come.
All right, good enough. These Spartans are getting on my nerves. All right.
Judge, we have reached a resolution in this matter. My client will be pleading guilty to one count of retail fraud second.
Yes.
And the original charge of retail fraud first would be dismissed.
And then it's okay for him to seek a deferred sentence.
Correct.
Good. May I have him sworn?
Right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the self you got?
Yes.
State your name.
Rakesh Sabharwal.
All right.
Me to take the proofs, Your Honor?
Pardon?
I can take the proofs if you like.
Well, I gotta ask him his question.
Got it.
Sir? It's this court's understanding that you're gonna be pleading guilty to the charge of retail fraud in the second degree.
Yes, sir.
That's a misdemeanor punishable by up to 1 year in jail, a $2,000 fine plus court costs. The fine could be increased if 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes, sir.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court. You understand that?
Yes, sir.
Understanding all that, you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty, sir.
And you understand that by pleading guilty, you will not have a trial of any kind?
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, sir.
Any question about any of those rights?
No, sir.
Look at paragraph 5. Those are, there's a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right?
Yes, sir.
Are you on probation or parole?
No.
No? Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
and of your own free will?
Yes, sir.
All right. On May 30th, 2024, 254 Briarwood Circle, that being the Sunglass Hut. What'd you do on that date that makes you think that you're guilty? Counsel, if you wish to voir dire, you may.
Absolutely. Judge, I believe it was the 29th. Sean,
What did I say?
it's 30th.
I have the 30th.
I have the 29th on the report. Rakesh, on the 29th or 30th of May, were you at the Sunglass Hut at Briarwood Mall in Ann Arbor?
Yes.
And did you walk out of the store with several pairs of sunglasses totaling under $1,000 from the store without paying for them?
Yes.
Okay. And that was in Ann Arbor, Michigan?
Yes.
Washington County? Yes.
Yes.
Okay, very good. Judge, I believe
The
I'm.
store was open to the public at the time? The store was open to the public?
Yes, sir.
You didn't have anybody's permission to take that property, did
No.
you?
No.
And the property that you took was property that that store had offered for sale?
Yes, sir.
All right, counsel, I complied with the court,
Satisfied,
but would it
Your
be
Honor.
proper to, thank you. Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Precinct's investigation and report is ordered at 15th District Court probation sentencing, and this will be
March 28, 8:30 before Judge Perry.
March 28, 2025, 8:30 before Judge Perry. Bond will continue.
Thank you very much, Ron.
Thank you.
very much.
Thank you. Good to see you, Judge.
Good seeing you. Courthouse case, People versus recall Jay Mahler.
Larry Margolis on behalf of Mr. Mahler. Good afternoon again, Judge. Jay, please unmute yourself and state your name for the honorable court.
Mr. Mahler, are you're waiving your right to a preliminary examination?
Come on, Jay. I'm so sorry, Judge.
I think he's frozen.
Then you're gonna pass me and I'll never see you again.
Yeah, I don't know. Oh, there he goes. All right, Mr. Mahler, leave. Can you unmute? I see you now. Okay. Mr. Mahler, you're waiving your right to a preliminary exam?
Yes, Your Honor.
That's a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed them. You understand that?
Yes, sir.
And you understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, I understand that.
People also waive their right?
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on both counts. Mr. Margolis.
You'd waive a formal reading, Judge. I ask you to enter a plea of not guilty.
Defendant having waived formal reading, pleading not guilty, court will enter those pleas to both counts. Pretrial will be set for
April 21st at 1:30 before Judge Hamud.
April 21st, 2025, 1:30 before Judge Hamud.
Your Honor, would you be able to still sign that proposed stipend order?
The stipend order to do what?
To appear to use the internet for purposes of court proceedings and necessary medical treatment.
The people stipulated to this?
Yes, Your Honor.
Correct.
All right. Then I will sign it.
Thank you, Judge.
All right. Bond will continue.
Have a good day.
All right. Thank you, folks.
My apologies for not being here Tuesday evening.
What did you say?
My apologies for not being here Tuesday evening.
Yeah.
I will see you this upcoming Tuesday.
Oh, joy. Yeah, we weren't alone, so it was okay.
Yes. May I approach to sign the?
Need to sign the information. So 3? Really? I'll get bored. Things go, hey, oh, never mind. Of course, answering recess. Let's call the case of the people of the state of Michigan versus Durrell Hicks.
Good afternoon, Your Honor. Amy Reiser appearing on behalf of the people.
Good afternoon, Your Honor. Sam Bernstein with and on behalf of Mr. Hicks. Seated at the table.
Bernstein, this is your motion.
Your Honor, yes, I filed a motion. I know the court reads all pleadings very carefully. I did read the prosecution's motion. I guess in all candidness, there's information presented in there that does contradict some of the things I'm saying. So I would just rest on my written motion, Your Honor.
Mr. Reiser, anything you'd like to say?
Thank you, Your Honor. We're asking that the motion to reduce the bond be denied. One, I don't think it was an abuse of discretion for the arraigning magistrate to deny the bond pursuant to the court rule and statute based on the charges. Furthermore, as I indicated in my response, the defendant did not abide by bond conditions and violated those bond conditions from the jail. He does have multiple bench warrants out of Detroit, so I don't believe he would be likely to appear. So I don't think that there's anything that's changed other than him not complying with the orders from inside the jail. So we would ask that the bond remain denied.
Anything else, Mr. Mercer?
No, Your Honor.
All right, the court having reviewed the defendant's motion as well as the people's response to defendant's motion to reduce bond. In order to change the bond, I'm not sure necessarily that I need an abuse of discretion standard, but what is clear to the court is, I would agree with the people that the magistrate did not abuse their discretion in setting the bond or denying any type of pretrial release. The defendant is charged with homicide in the case, given particularly the facts as outlined by the people in their response. The court would find that the likelihood of conviction in the case, that there is a high likelihood of conviction in the case of this offense, given the defendant's proximities to the deceased, as well as his activities, or at least as alleged that night, if shown. So for those reasons, the court does believe that it was appropriate under the court rule to deny defendant's pretrial release, given that he is charged with the predicate charges, as well as the fact that the court does believe that his likelihood of conviction is great, or the presumption of a conviction is great. I would further indicate, just so the record's clear, that unless the court could determine, which almost shifts the burden, that the defendant would likely appear at these proceedings, I think there is a question, given his non-appearance and other matters and bench warrants, as to whether or not the defendant would proceed in the case. So it's not shown that the defendant would be likely to appear, which is really, I guess, how it would have to go. So for those reasons, defendant's motion to reduce bond or to change bond in this case is denied. Bond will remain as denied. Thank you.
We still have the PCC if we could, Your Honor.
Yes, go ahead.
I am still waiting on certain medical documentation such as CT scan, x-rays, and MRIs. I hear what the court is saying, but we are still actively fighting the case, and we've requested those. I think I did receive an email about a month ago that they have been requested from the hospital and that they are on their way to me. I don't know how close they may be, but we are requesting an adjournment to obtain and review those.
All right. Is there any, Mr. Reiser, do you have a time frame as to when all that information may get to the people and then ultimately to the defense?
I want to say, yep, I just sent an email to our discovery clerk. Detective Yeager received the MRI and the CT scans. He had to forward 3 discs to my office via interoffice mail. So once those are, and that was on 2/18. So once those are received, I will make sure they're available for pickup for Mr. Bernstein. Although I want to make sure that we can actually duplicate them once they're here. So I'll check in with.
Okay. And then I guess just timing wise, I mean, I could set it out 2 weeks, allow that process to happen, but I'm presuming that the defense is going to have someone maybe potentially analyze that and clarify what it may or may not mean. So
I would ask for March 20th to be a little bit safer, Your Honor.
Okay.
Thank you.
There's no objection from the people.
No
Probable cause
objection.
conference. I'll adjourn that out to March 20th, 2025, 9 a.m. or as your invite indicates. Bond
Thank
in
you.
this case will continue as denied.
And does Your
Thanks
Honor
for
want
your
an
time.
order denying the defendant's motion?
Yes, please, if you could.